All right, we are live.
All right, fantastic. Thank you.
Madam Clerk, good morning. Today is May 7th, 2020, and welcome to this sitting of the Massachusetts Appeals Court. Let me introduce the panel. I'm Justice Eric Neyman, and sitting with me today are Justice John Englander and Justice Catherine Hand. We will be your panel for all 6 cases today. I'll remind you that the usual rules of the Massachusetts Appeals Court are in effect. Accordingly, each side will have 15 minutes to make its argument. There is no rebuttal in the appeals court. I would urge counsel to make your best argument first. We have read the briefs. We are intimately familiar with the record on each case, and we are also familiar with the case law, but your time is yours to use as you see fit. I will also remind counsel that all of these cases are being live streamed on the appeals court YouTube channel, and they are also being recorded. So please keep that in mind, both when you're arguing and when your argument is completed. And with that in mind, we'll call the first case, Commonwealth versus Metellus, 2019 P 1149. And we will hear first from counsel for the appellant, Mr. Fox.
Good morning, James Fox on behalf of Mr. Metellus. Just as some preliminary housekeeping on my end, we are working out of the house, so if there's any background noise, just indicate, and I'll do what I can to kind of rein things back in. Mr. Metellus advances 3 claims on appeal. The first, his primary claim is the GPS claim. Second, subsequent bad acts. And third is the evidence sufficiency. I'd like to spend the balance of my time addressing the FELIZ Johnson claim. If there's time, address the bad acts and rest on the brief with the evidence sufficiency unless the court has questions otherwise. The GPS claim essentially is that with FELIZ and Johnson, the sentencing court is required to make individualized determinations about the appropriateness of GPS, balance the Commonwealth's needs against the defendant's loss in privacy. Mr. Metellus, in fairness to the Commonwealth, this case law came out after he was sentenced, but the case law under FELIZ and Johnson dictates that the court is required to make an individualized determination. It's not a check the box, impose GPS and move forward.
Is there any case law, counsel, that addresses the issue of the retroactive application of FELIZ? Any case law that discusses how an appellate court ought to deal with a situation like yours where the decision on GPS was made before FELIZ came out?
I can try to get supplemental authority. My understanding always was that the case isn't final if the appeal is lost, so that the new law applies to the cases up on appeal. I can get you supplemental authority on that. I don't have a cite for you this morning. The scuttlebutt in the defense bar is that a lot of lawyers have been filing 30As. My consideration was that maybe that would be the appropriate attack on this, to file a Rule 30A asking for resentencing in front of Judge Barnes. My concern was that when FELIZ came out, I was in the briefing stages of this case. Would it be waived if I didn't put it in the brief? So it is being used to address cases right now. I don't have a cite for the court, but the practice right now is lawyers going to court, filing Rule 30A motions, citing that the defendant is constrained against the Constitution. So I suggest to the court that it is a live issue before the court. The Commonwealth's brief tends to focus more on, make more of a harmless error argument. That regardless.
So Mr. Fox, I'm sorry to interrupt, but
no, please.
My understanding of this portion of your argument then is that because your case was pending on appeal at the time that the case came down, that it may be retroactive, or was your case tried before the new SJC case law came down?
It was tried before. The case came out, I believe, in April 2019. I'm working off my memory for the dates, but I believe the sentencing was at the end of 2018. So Judge Barnes did not have FELIZ and Johnson for his benefit.
Okay, so you can submit a 16L letter if you'd like with the authority you referenced, but I have a slightly different question, and that is whether or not the absence of any objection impacts either your argument or our standard of review.
I don't think it impacts the standard of review because it's a constitutional protection. And the argument for the defense side would be that the being sentenced without the protections of the Constitution is a substantial risk of miscarriage of justice. The court is correct that even before these new authorities come out, that a lot of times defense trial attorneys will make the argument in hopes of issue preservation. But there is no preserved issue for the court.
Yeah, but do you have a case that says that just because it's a constitutional concern that you don't have to raise it below?
Yes, in the standard of review, my argument is that it's it changes the review standards, not preserved error. And there is no case that says you don't have to preserve an issue below. That my understanding is the whole need for issue preservation is to give the trial court the chance to get the issue right the first time, and have the appeals court serve its role as a court of review, so that attorneys aren't raising ad hoc issues for the first time at the appellate court. So it's not raised below, it's not preserved error. The argument is that it's a constitutional protection. It did come out after Judge Barnes imposed sentence, and it does.
There's a lot more to it, in my opinion, than just hey, we want to give the trial court the first shot.
Okay.
This case is a great example of that, where there's a balancing test that FELIZ describes, right? And the notion that we should be doing that on appeal strikes me as pretty darn difficult. So, or at least not the ideal situation. Let's put it that way. Now, but I'm still stuck on. You say there's substantial risk of a miscarriage of justice because he's got an unlawful restraint, right?
I have to go back. I believe I'm not, the brief isn't in front of me. The review standard in Part C, the third argument, is what I'd be relying on. But in essence, I'm not asking the court to resentence him on appeal. It's a remand for Judge Barnes to consider whether GPS is appropriate. So the court's correct. The appellate court really is not in a position to make sentencing decisions. The Commonwealth appears to make a harmless error argument, essentially arguing that there are factors that support GPS imposition. The defense argument is that an individualized determination is now required. A sentencing judge has to sit there and tick through the issues in his or her own head. That
Have you filed a 30A?
No, in fact, that's an option. I gave some thought to stay in the appeal to file the 30A, and it was just a discretionary issue. I actually had two cases in similar posture at the same time. In one case, the Commonwealth cut me off and went right into the trial court and resentenced the defendant. In this case, the Commonwealth responded with essentially harmless error arguments. So he, I don't know. My only thought was, is the issue waived if I don't put it in the brief? A beep went off. I don't know if that's significant.
No.
Okay. All right. So essentially, my understanding is that as long as he's still incarcerated, which he's not incarcerated formally right now, but he has GPS, so there is some restraint on his liberty. The Rule 30A is still in play unless and until he's released from supervision.
When does his release from supervision occur?
He had 2 years, 9 months to serve. I'm not sure what his wrap-up date is. He's wrapped up with his committed time. So, I mean, quite frankly, if he is wrapped up on his GPS, he'll have the relief he wants. But there is the...
Go ahead.
I'm just trying to give the court a moment to jump in. Sometimes there's lag on these videos. So if you want me to press forward, I will. Essentially, the force of the argument really comes, FELIZ and Johnson came out as twin decisions, basically. Johnson talks about the factors for the court to consider, but really the force of Johnson is in Justice Lank's dissent, where she talked about the overwhelming trove of data that the state will have for probationers that essentially rest in state repositories till the end of time. And there is an interest with the defendants in whether they want to give up their location data. So there is importance to this. It is something that should be considered by the sentencing court. And I believe, I'm not trying to pull a gotcha on the Commonwealth. FELIZ and Johnson did come out after the sentencing. It is not a preserved error down below, but it does appear that on some level, METELLUS should get resentenced, whether that's on remand from this court or filing the 30A if this court decides the issue is not appropriate.
And one of the issues is whether that's moot, whether the GPS is off him at this point. I just read the dates in your brief. It suggests that the GPS would remain on him until September of 2020. I see your brother nodding, so let's operate on that assumption.
Yeah, I don't have he's not on my video here, so your folks are a little ahead of me on that.
Okay. FELIZ mentions as one of the considerations whether there is a, quote, geographically proximate victim. And in this case, as I understand it, the evidence as of sentencing would have been that there was a geographically proximate victim, that your client was living in the neighboring town, right? The victim is in, I'm probably going to get this wrong, Everett or...
No, the court's fine. The victim attended Everett High School, lives in Lynn. As of the time of the sentencing, lived in Lynn with her grandparents, plans to, it was in the discovery, she plans to go out to college out west. I don't know if that's still in play or not. There's no indication, though, that Metellus made any threat to the complaining witness. These are factors to consider also. The line of question the court pursuing would permit GPS in essentially every case. It's almost axiomatic that
it would not in FELIZ, where there is no, where it's child pornography, and therefore there is no victim like there is in this case.
Well, that's a bit of a point of debate, but that's I think there is a victim of child pornography.
I think, as I stated, it's hard to debate. There's no victim as there is in this case, where there is an actual person as to which an assault was found to occur.
That's not a consideration of FELIZ or Johnson. The court's making, and the Commonwealth tries to make the same distinction, that there's a distinction between physical crimes against the person and property crimes. I believe Johnson was a housebreak case where there were several housebreaks on the South Shore, and FELIZ was a child pornography case. So I think
FELIZ doesn't provide an exhaustive list of all of the factors to be considered. That would, for instance, be something maybe that a judge could consider on a case-by-case basis, isn't it?
Johnson provides more of the exhaustive list. Johnson discusses a constellation of factors. There are the traditional sentencing factors that the Commonwealth always argues at sentencing, and there are other issues, as the court earlier indicated. Does the defendant have an ability to follow probation? Are the goals of probation furthered by GPS, meaning that does he have a tendency to violate certain boundaries? Here, and as was argued at sentencing, the Metellus did not make any threats against the complainant before trial. He showed up at trial. There were no issues there. So essentially, what FELIZ, I'm sorry. It's difficult to video tell if you're getting ready to ask a question. So essentially, what FELIZ really calls upon in Johnson, FELIZ calls on the court to make the individualized determination. Johnson gives us a list of specific factors, and the dissent in Johnson really talks about why we need to have some type of check on the GPS data troves. So that's where he'd be.
And to be clear, you're not asking us to remove the condition of GPS monitoring. You're simply asking for a remand for the trial judge, the sentencing judge, to evaluate these fact-driven considerations, correct?
Yes, and I don't know if the court, obviously the court could do whatever it wants, but my understanding is the sentencing.
Not quite.
Yeah,
no,
we don't find it quite that way.
Well, you have a little more than I do here, but essentially, Metellus is asking to be sentenced by Judge Barnes. If you want to get to the end, the final request right there. And as I said, the law came out after sentencing. It's not a preserved error, and the Commonwealth was not aware of it as sentencing. It was not an issue that was thrown to the trial judge. But there is a lot, the whole issue about reasonable expectations of privacy, search and seizure, in light of modern technology. The McCarthy case came out of the SJC in April. It's really not on point to this case here, but what it does, that's the license plate reader case off the Bourne Bridge. It really talks about what are our expectations of privacy in light of this modern technology. These expectations of privacy are not gone. And, I share the court's concern about whether this is still in play, whether the issue is moot, or what the appropriate avenue is. Metellus could pursue a 30A. That may be the appropriate route to go. My thoughts here were just preserve the issue, put it up to the appeals court.
We appreciate that. You have 2 minutes left. Would you like to address your other issues?
Briefly, on the evidence sufficiency, I believe that's adequately addressed in the brief. It was a competing credibility contest. On the subsequent bad acts, the court's familiar with the facts of the case. Essentially, there was an alleged assault in October. At a baby shower in January, Mr. Metellus is alleged to have pulled up the shirt of the complaining witness. That came before the jury. There was some confusion among the jury. They were asking for a verdict slip for the January charges or the January conduct. There is some, it does appear that the jury was considering that as criminal conduct. METELLUS submits on appeal that the prejudicial impact of the removal of the shirt outweighed any
Well, the only evidence I saw was he pulled down her shirt, and that was the sum total of it, right? We don't even
Yes.
know what that means. Could have tugged on it, and that's it, though, right? That's the only evidence in the record.
Yes, it's. I can tell you what's in the police report. That's not in the record. It appears to be potentially an IAB. Now, whether he made contact, the record says he pulled the shirt down. Whether he made contact would be determined of whether or not it was formally an IAB. Fair to say it's probably a subsequent bad act, and it was not probative. It tends to profile the defendant, make him look as if it's a pattern of conduct beyond what the jury is properly permitted to consider.
Did defense counsel, sorry to interrupt, did defense counsel request a limiting instruction?
No.
No. Okay.
The defense counsel was addressing prior inconsistent statements in the charges. That's not an issue on appeal. Defense counsel, when the jury question came back about the January conduct, then the court re-instructed on the charges being before the jury, just being the October incident. On this end, in fairness,
I'm sorry, Mr. Fox, your time has expired. Let me just.
That was be my question. I don't see any timer on this end. I thank the court for its time.
It's okay.
And I'll thank you.
Okay, let me just double check though. Justice Englander, any further questions?
No.
Justice Hand?
No, thanks.
Okay, thank you, Mr. Fox, and we'll now hear from the Assistant District Attorney on behalf of the Commonwealth.
Thank you. May it please the court, Greg Delizio, Assistant District Attorney for the Commonwealth. I was also the trial prosecutor in this case out of Malden District Court. We would ask that this conviction be affirmed by this court. First, there was sufficient evidence of an indecent assault and battery. Second, the subsequent bad act evidence, the uncharged conduct there, its probative value did outweigh any risk of unfair prejudice. And finally, no remand for resentencing is necessary because the imposition of the GPS was reasonable. There was particularized reasons for the GPS being imposed in this particular case.
So let's get to the, please, Judge.
No, go ahead. Go ahead, Justice Neyman, you.
Just some background questions on the GPS issue. The questions are, number one, what is the standard of review here in the absence of an objection? Number two is whether or not the FELIZ case is retroactive.
Understood. The FELIZ case doesn't necessarily expressly say whether or not it is retroactive. Certainly, I think an argument could be made that it is. But even if it is, I don't believe that a remand for resentencing is necessary because this court, if you look at Johnson, the court looked at the record below and essentially stated that there was legitimate reasons, there was reasonable reasons for the imposition of the GPS, but the record made it clear that the GPS was warranted. So I would ask that this court do the same. As it relates to standard review, I would certainly my contention would be that it would be harmless error. I think.
Is it harmless error or substantial risk of a miscarriage of justice in the absence of the issue being raised by the defendant at trial?
I would suggest it's harmless error, given that there was I don't believe there was an objection to the GPS at the time at sentencing. So I would ask that it be harmless error for this court. But even if
figure that out, I mean, there's got to be some law. This is a constitutional issue, right? FELIZ says that if the restraint is imposed without the appropriate balancing, or if they do the wrong balancing, then it must be removed as a matter of Fourth Amendment law. So, usually substantial risk of a miscarriage of justice is in the context of a criminal defendant who has lost his liberty. This is a Fourth Amendment question, not deprivation of liberty question. I know that they sound the same in this context, but I think it's a little bit different. And does substantial risk of a miscarriage of justice apply to a Fourth Amendment search?
I would say it wouldn't at this juncture. I mean, I think even if the court looked at it purely de novo, that this court can look at the record and determine the reasonableness of the imposition of the GPS without the need for a remand. for the GPS issue itself.
Does
Because
imposition, I'm sorry, does imposition of a GPS device constitute a deprivation of liberty?
absolutely.
If it does, then why wouldn't the substantial risk standard apply?
I just think that given there was no objection at the court below, that it can be simply harmless error at this point.
Police is not decided on due process grounds. I mean, I don't think it is. I just read it. It's decided on Fourth Amendment grounds, right?
Certainly. But I think even if
The
the,
question, as Judge Neyman poses it, whether there's also a Fifth Amendment component to the imposition of the restriction.
I don't think FELIZ addressed any Fifth Amendment type issue. It was as the court just stated, the Fourth Amendment as well as Article 14 with Massachusetts Constitution. So I think, but even looking at that and looking at Johnson, I think this court can review it and determine from the record itself without a remand for particularized reasons. Because as opposing counsel pointed out, the FELIZ decision had not come out at the time of sentencing. So there would not be any sort of written findings on the particular reasons for the GPS. But here, unlike FELIZ, we have a specific victim. This is not a non-contact sex offense as is in FELIZ. Here, there isn't a generalized interest in protecting the public at large. This is particularized to protect the specific victim. There was a specific stay away order that was ordered. And the GPS would help both ensure the defendant's compliance with that and deter him from violating that particular provision. Additionally, the victim was in geographic proximity to the defendant. At the time of the incident, the assault, this victim and defendant were living in Everett. And since that time, the victim at the time of trial and at the time of sentencing was living in Lynn, whereas the defendant was living in Everett, just a town over. So given the geographic proximity.
Aren't those arguments that should be directed to a trial judge who's now been told that he needs to balance a variety of factors to make a decision about whether to attach a GPS rather than the first instance?
Well, certainly that would be something to address if there were a remand. But I think if you look at Johnson essentially decides the issue without the remand and states that looking at the record, it's clear that there was legitimate probationary reasons for the imposition of GPS, vis-a-vis that it was reasonable.
Johnson is different, right? Johnson is not in the context of what the appropriate sentence should have been. Johnson is in the context of whether or not there'd been a Fourth Amendment violation. I'm looking at it now, but we're just refreshing myself. Tell me if I've got that wrong.
No, I think your honor is correct on that. But I think the same principle would apply, that this court can look at the record itself without remanding the case for resentencing and look at the factors that are outlined by FELIZ that are present here, and the clear distinctions from FELIZ in this case, where we have an actual victim that is geographically proximate to the defendant himself, where we do need to ensure that a stay away order is complied with and deter him from violating that stay away order, as opposed to sort of the generalized risk of safety to the public itself in FELIZ.
Right, but to piggyback on Justice Englander's question, FELIZ says at page 700, first it notes that mandatory blanket imposition of GPS monitoring absent individualized determinations of reasonableness is unconstitutional under our Declaration of Rights. So the concern is, are you asking us to make those individualized determinations of reasonableness?
Yes, I think this court can look at that constitutional issue and look at the record and make that determination of reasonableness. And I think given the fact that there is a specific victim here and that the victim is geographically proximate to this defendant, and looking at sort of the severity of the conduct in this case of which the defendant was convicted, that the GPS was reasonable, that it was legitimate, and was did have a nexus to probationary goals, that being have him stay away from the victim, ensure his compliance with that stay away order, and certainly deter him from any violations of that.
Reframe that a little bit. Maybe the argument is, where this issue is not raised before the trial judge below, the question for you guys is whether or not there is a clear constitutional violation. And under circumstances where there would be a basis for the judge to conclude that it was reasonable to impose the GPS restriction, we can affirm on that ground.
Precisely. That articulated what I was trying to say far better than myself. So that would be my contention, that this court does not need to remand it for resentencing because the GPS on the record was reasonable on the constitutional issue itself. But as it relates to sufficiency, despite opposing counsel's argument that credibility was an open question, the jury answered that question with their verdict. Certainly this court can assess what the victim's testimony was and whether or not it amounts to an indecent assault and battery. It's not this court's role to assess whether or not the victim was credible.
What's the relevance of the event in January?
The relevance of the event in January. So the event in January was roughly 3 months after the alleged sexual assault and roughly 1 month before she reported the sexual assault to the police. So the relevance of it shows that the defendant's intent, it shows his motive, it shows the nature of the relationship.
What did it show at all?
So he approaches her, he comments on her looks, he calls her beautiful. So that would certainly show the defendant's intent, that physical attraction, if not sexual.
Beautiful.
Yes, Your Honor, in this context, absolutely. Given that 3 months earlier he had sexually abused her and then approaches her, begins removing her headband and glasses. Certainly that's not a sexual incident, but the fact that she's telling him to stop bothering her, to give her things back, the fact that he's
testimony that she told him to stop.
I believe she did on the record in the first day, I believe page 115, she did. And then it's him physically touching her. Obviously that's not, I'm not suggesting that's sexual in the fact that he's touching her, but the fact that he's bothering her and he's taking it upon himself to physically touch her when she's telling him.
She did so testify. I apologize.
No apology necessary, Your Honor. And the fact that he's commenting on her looks, calling her beautiful in the context of this relationship, it shows his sexual interest in her, as well as the fact that he's touching her without her consent, even if it was in a non-sexual way. And then he pulls down her shirt as he gives her those items back. Certainly the record could have been more clear and the testimony could have been more detailed in regards to that incident. But certainly the risk of prejudice here is substantially low. When you look at the spectrum of cases, particularly cases involving sexual abuse, in the landscape of uncharged conduct that's been admitted, both prior and subsequent bad acts. If you look at cases where it's criminal level incidents that are uncharged, involving even different victims, I'd point the court's attention to Commonwealth v. Hanlon, where other incidents of sexual abuse involving different victims was admitted and upheld. Additionally, the fact that there's been cases including Santino and Santiago, where there's uncharged sexual abuse on the same victim. And then even less severe, you have sort of inappropriate type sexual behavior, but non-criminal, being admitted in cases like Commonwealth v. Holloway involving the same victim. And here it's far more mild type incident than that type of evidence that's been admitted in other cases. But I think the Holloway case is probably closest.
Well, as I listen to you go through that litany, it concerns me that we've almost made an exception to the prior bad act law in the context of sexual abuse cases. That is honestly the way it sounds like the Commonwealth is arguing it to us. I mean, prior bad acts are not supposed to go in. Subsequent bad acts are not supposed to go in. As a general rule, you need a good reason to do it. There was a point at which the Supreme Judicial Court said, we've had enough of the way you're trying these sexual abuse cases. You only get one fresh complaint. And there has to be consideration given to the validity of the kinds of prior and subsequent bad acts that are being put in, it seems to me. Or we're going to wind up in the same place.
I certainly understand that concern, but I think that sort of goes to
well, is the law different in sexual abuse cases than in other cases with respect to prior bad acts?
It is not. It is not. It's the same standard of whether the risk of prejudice, outweighs its probative value. But simply my point in pointing out sort of the spectrum of cases is merely just to draw this court's attention to the severity of other cases where uncharged conduct that rises to a criminal level has been admitted and been upheld. Whereas in this case, it's non-criminal, it's non-sexual abuse type case, but it illuminates the relationship. It shows that his intent, and it shows that, and in a way, it corroborates the victim's account, the fact that he's touching her, even if it's not in a non-sexual way, without her consent and bothering her and commenting on her looks itself. But as it relates to the specific sufficiency of the evidence in this case, the jury heard from the victim. They heard her testimony that the defendant, her stepfather at the time, when the victim was 17, entered her bedroom, touched her without her consent. He pulled down her underwear, jammed his head in between her legs, and bit the top area of her vagina. That is, without a doubt, an indecent assault and battery. So I would ask the court to affirm this conviction and to not remand the case for resentencing, but because such resentencing is not warranted at this time, looking at the landscape of FELIZ and the record before this court. So I would, if there's no further questions, I would rest on my brief.
Justice Englander?
All set.
Justice Hand?
No, thank you.
Okay, thank you, counsel, for your helpful briefs and helpful argument. And the case is submitted. Thank you.
Thank the
Thank
court
you.
for its time. Take care.
Thank you.
Thank you.
All right, we are live streaming.
Thank you. Good morning, counsel. I apologize for the delay. We're calling our second case, Commonwealth versus FELIZ, 2018 P 1632. I will remind counsel that this is being live streamed, and it is being recorded. So please conduct yourselves accordingly. And I'll also remind counsel this case is partially impounded. So please refrain from using the names and the information that is subject to the impoundment order. We will hear first from the appellant, or counsel for the appellant, Attorney Cusack.
Thank you, members of the panel. May it please the court, Kelly Cusack on behalf of the appellant Michael FELIZ. Given the impoundment orders, I will refer to the child witness as Jane. There are three issues that I've raised on appeal on behalf of Mr. FELIZ. I think the majority of my time I will spend on the two strongest arguments, one about the bad act evidence and the second about the prosecutor's closing argument. Assuming there's enough time, I will address the sufficiency of the evidence on the issue of penetration. First, the defendant is entitled to a new jury trial because it was a prejudicial error for the court to admit testimony from Jane that she was shown a gun by the defendant, Mr. FELIZ, during a ride to buy drugs, because it was shown as a brag in jest and not as a threat to Jane. This issue was preserved, and this court should review that error as to determine whether or not it was prejudicial. I would suggest to the court that the testimony was irrelevant and highly prejudicial, not outweighed by any probative value. Jane, I think the context of the testimony is also important of when the particular testimony was raised. If you look at Jane's testimony, she first begins to describe her personal life. She introduces herself, some background information. Then the assistant district attorney asks her questions about how she met Mr. FELIZ and describes that one first night that she spent at the apartment where she partied and took drugs and had, part of my argument is that there was insufficient evidence of penetration, but that she went into the bathroom with Mr. FELIZ and there were sexual acts that happened there.
Right. So why is the evidence of the defendant showing a gun to Jane, which for the record is a pseudonym, why is that information not relevant to the charges of sex trafficking and enticement of a child, particularly where those, I think both crimes involve the element of enticement or recruitment or causation? I mean, couldn't someone showing a gun to a minor speak to those elements and show why they felt compelled to do what it is that they ultimately did?
In this particular case, I think that does not, because Jane is clear throughout her testimony that she was never in fear of the defendant, that especially the enticement statute and the trafficking statute don't require any force or coercion. And the elements that Your Honor is referencing are about enticement, recruitment. And I would suggest that the gun had—
Or causation.
I'm sorry?
And causation as well.
And causation. And I think that Jane was clear during her testimony that she was never in fear of the defendant, that she, when asked to describe her relationship with him, that it was good, he was nice to her, that she was his girl, understanding the age difference. But I would suggest that the gun is not relevant to those particular elements in this kind of case, where there was no compulsion or the impermissible purpose that Mr. FELIZ was a violent person who had access to weapons. And again, the
Why is that
context—
not for, I'm sorry to interrupt you, but why is that not for a jury to make that determination as to factually how that may have impacted the victim here?
Because I think that you have to look at the inflammatory nature too of a gun itself and why it shouldn't have been introduced when it's not particularly relevant to the indictments as charged. And that would be my argument, that it's not relevant to those particular indictments, that there is no issue of force or coercion or weapons charges here, and that it shouldn't have been before the jury at all, especially where Mr. FELIZ is charged with particularly immoral crimes that are already inflammatory in nature. Adding another piece of inflammatory evidence.
You're making two arguments, right? One argument is it's irrelevant. The second argument, when you start talking about how inflammatory it is really that the judge misweighed the prejudice.
Correct.
What's your best case for that? Because I just looked through a few of them and I had trouble finding one where a court said, this was so inflammatory that you talked about a gun that we're going to reverse the criminal conviction or vacate it.
I don't have a case on point, and I should tell Your Honors, I looked for exactly that type of case, and I have been unable to find one. I would suggest that the cases where a gun has been admitted that are cited in my brief address that gun is admitted, or testimony of someone with a similar gun that was used during the crime was seen with that defendant months or before.
Right.
Is admissible for the either that it was in fact the weapon or that they had access to weapons that could have been committed in the crime. I don't have in any case that I've been able to locate, and I'd be happy to submit a post-argument letter if I could find one about a gun in and of itself is inflammatory. I think the court can understand and take note, and I would suggest that a gun is an inherently dangerous, deadly weapon. And I think that there's a number of cases out there that discuss that particular aspect of a gun. And also that in the context of gun legislation and public media about gun mass shootings, I think it's it's inflammatory by its very nature. And I would suggest that there was no relevance, and that also it was inflammatory. And again, going back to sorry, go ahead.
No, I didn't mean to interrupt you. I'll wait till you finish your point.
So going back to the context of when it was actually raised, I think is very important, because after she describes her relationship, Jane describes her relationship with Mr. FELIZ, how it started that first night. At that moment is when she is asked about seeing the gun. So there's this primary and recency issue with it, that then she has this one night with Mr. FELIZ where she parties, then she's shown a gun. And then there's the more testimony about the other nights that she spent there and performed sexual acts with other individuals at the request of Mr. FELIZ or at his behest, based on the context of the evidence. So I think the nature of when it was introduced.
To follow up on Judge Neyman's question, I mean, that would be the very logical order for a prosecutor to follow if they were building a case for sex trafficking, that there is, she has a relationship with him that's established. Then he shows her something that could cause her to be in fear of him, and then he asks her to start doing things for him that are engaged in sex. What's wrong with that as a logical way for the prosecutor to pursue the case?
I'm not saying it's an illogical way. I'm saying that when you're taking into consideration how this bad act evidence was introduced and at the timing of when it was introduced, I think it was irrelevant to the charges. At the trial court level, the Commonwealth raised the issue of that it was relevant to the threats charge, which I would disagree with and point out that the timing of the threat was a phone call made to the mother where Jane was not present, not involved. There's no indication on the record at all that Jane and her mother had in fact discussed the threat at all. And so there's no.
Suppose it was relevant to another charge that the Commonwealth didn't mention in their argument. Does that matter?
No, I think this court can certainly review that issue if it was relevant to any of the other charges. I know the Commonwealth in their reply brief brings up the issue of the enticement of a child, which again, I would suggest to the court does not require any force or coercion, and the inflammatory nature of a gun is difficult for a jury to evaluate, especially without any limiting instructions. While there was no limiting instructions requested, I would suggest that without such a limiting instruction, the jury was left with no way to discern how to utilize this particular piece of evidence in the context of the case.
Well, no limited instruction was requested, and that could easily be tactical, right?
It could. And it wasn't requested in final jury instructions. And I'm not suggesting that a court has to sua sponte give a jury instruction in this particular circumstance. But I think if you're looking in the overall case and the inflammatory nature of the evidence, that I would suggest to the court is irrelevant. A jury instruction should have been given at the time that the evidence was introduced. Unless there's any other questions on that particular issue, I'll use the rest of my time for my second bigger issue, that the defendant was entitled to a new trial because the prosecutor's closing argument vouched for the credibility of the cooperating witness, which influenced the jury's verdict. There was no objection at the trial level, so this is unpreserved with a substantial miscarriage of justice standard. I would suggest to the court that the evidence against the defendant, contrary to the Commonwealth's reply brief, was not as overwhelming as the Commonwealth asserts. The testimony of Jane was in parts corroborated by this corroborated by this cooperating witness. And there was little to no forensic or scientific evidence tying Mr. FELIZ to the crimes at hand. In fact, the forensic evidence and the YSTR DNA that was discovered on the condoms actually came back to the other two individuals, Angel and Michael Alicea, who the defendant's argument at trial were the real bad actors or the real culprits here, that Mr. FELIZ's his only crime was to introduce Jane to these particular individuals. The cooperation agreement, I think, and I suggest in my brief, gives a substantial benefit to the Commonwealth, where you have an individual who participated in the exact same crimes and is getting a deal with the Commonwealth. The Commonwealth's closing argument went to the heart of the case because it was the only other witness who corroborated details of Jane's testimony. I would suggest that the prosecutor impressed the age, education, work ethic, and that the story of Mr. Alicea had the ring of truth, that he was barely an adult himself at the time. He was only 18 years old. And so appealing to the jury's sympathies in that way and vouching for the credibility, I would suggest what influenced the jury's verdict, and the defendant, Mr. FELIZ, is entitled to a new trial as a result. if there are no further questions from the panel, I would rest on my brief for the remaining argument.
Justice Hand,
No, thank you.
Justice Englander.
No.
Okay. Thank you, counsel. We will now hear from the appellee.
Thank you. May it please the court. My name is Emily Walsh and I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The trial judge acted within her discretion in admitting the evidence of the gun and that the defendant showed the victim a gun, which was relevant to her state of mind. The defendant was charged with trafficking a person for sexual servitude and with child
It was
enticement.
relevant to her state of mind.
It would,
I mean, it's a phrase. It means nothing to me unless you give me some context for it.
Sure. So the child enticement and sexual servitude both question whether the defendant recruited, enticed, caused, persuaded the child to do certain acts or engage in commercial sexual activity. In this case, the defendant showing the victim a weapon is certainly a way to persuade her or exercise some control over her. So that goes to her.
That argument, counsel, I get that argument. That is not an argument that was made to the judge below when you were trying to admit the gun, was it?
It was. So the argument below did talk more about threats than it did about the other two charges. And I would suggest that the case for admission is stronger for sexual trafficking and sexual servitude and child enticement. But
did he actually mention those when he, so there was no motion in limine here with respect to the gun, right? It came up.
I believe it was only the discussion at sidebar at trial. And it was discussed, and I believe the prosecutor said state of mind, and I believe she mentioned the other charges. You are correct that it did mostly focus on threats, but certainly, and additionally, this court can affirm on any basis. But additionally, while there's a very clear case that the trafficking for sexual servitude and child enticement, that the gun evidence is probative. It is also probative towards the threats. The defendant showed the victim a gun and then called the victim's mother and said, "I'm going to take your daughter to Lawrence and you'll never see her again." And while the viability of the threats, the gun evidence with regard to the threats depends on a communication between child and mother. But by the time he made that threat, they'd been reconciled. It was after the McDonald's
Did the mother
incident.
testify?
The mother did testify.
Did she say that she was aware that he showed her a gun?
No, it wasn't. It wasn't asked, and no. The threats. The relevance of the gun to the threats requires an inference that's not before the jury, which is that mother and child communicated. In terms of the gun evidence for the sexual servitude and child enticement, it goes to the victim's state of mind, her fear, her performing the sexual acts for him. And additionally, there was
your own
no
witness testifies unequivocally, "No, I wasn't afraid. He said it, he was joking." So what you're left with is he had a gun, which the cases say has its own set of inflammatory context to it, so that in general, you don't put that evidence in, even in contexts where the crime that's involved is a gun crime.
the child did testify that she was not in fear, but I do not think that her testimony prohibits the jury from finding that it was evidence of a relationship involving control and that the gun showed that relationship. Additionally, in weighing the probative versus—
You didn't try the case, counsel?
I did not try the case. In weighing the prejudicial versus the probative value, it should be considered that there was no argument whatsoever painting the defendant as a violent person. The defendant was painted as somebody controlling the victim.
Wait, does that cut? But we made it very, very clear that he had a gun.
Evidence was submitted that the defendant showed the victim a gun, which in the context of the charges of this case and the relationship between the defendant and victim is relevant to her state of mind. And if there were overwhelming evidence, if the Commonwealth argued to the jury in opening and closing, this was a violent guy, he has a propensity for violence as evidenced by this gun, that might be more of a problem. But in this case, weighing the prejudicial versus the probative value, evidence of the gun is not outside the range of reasonable alternatives.
Isn't this a case that cries out for a limiting instruction?
I mean, the case law is very clear that it's up to the defense attorney, and if it's not
Right.
requested, it doesn't need to be given sua sponte.
I understand that. You weren't the trial prosecutor.
I am not the trial.
Wouldn't it behoove the trial prosecutor to say, Judge, here's why this information is relevant. Here's what it speaks to. It speaks to state of mind, speaks to these elements of these crimes. But to remind the judge that, look, a limiting instruction would be appropriate here. At least so that way it gets on the record, and then defense counsel can be inquired of by the trial judge and either state, yes, we want it, or no, for strategic purposes, we don't want to emphasize it. We see this in case after case after case.
I agree with you.
And I understand that the
better.
obligation,
Sorry.
I'm sorry to interrupt, but I understand the obligation is on defense counsel, and we've said that. But again, wouldn't it behoove the Commonwealth to simply say those magic words, Judge, we have no objection to a limiting instruction here, and in fact, it would be appropriate.
Yes, that would have been better. It would have been better if there had been a discussion on the record about the limiting instruction, and that the defense attorney had put on the record that they did not want to draw attention to the gun mention by having a limiting instruction. However, the case law does make it clear that it's up to the defense attorney. It should not be given sua sponte. So even though things could have been better, that doesn't render this legally erroneous.
Well, does it say it shouldn't be given sua sponte or need not be given sua sponte?
I believe it says need not be given, but the case law also discusses how defense attorneys might not want to highlight this. And if they don't want to highlight it, they
But
should.
this defense lawyer was completely surprised. Now, I don't know if this evidence should have been produced in discovery in advance or not. But both the judge and the defense counsel were surprised by what the cases say is an important piece of evidence. And as I think your sister correctly identified, this is a farther removed use of a gun evidence than we usually see in the cases where the courts always say, you got to be careful about this kind of evidence. You got to be careful about it when it's not actually being indicated to be the instrument of the crime. It has particularly inflammatory impact. There was no heads up to the judge, no heads up to the defendant. And now we're saying, oh, the defendant should have done something. Well, he objected.
Your Honor, I could be wrong, but I thought that it was discussed at the beginning of trial, not just when it came up at the victim's testimony. I'm not 100%.
That would be great. There's no indication of that I could find in the briefs. And when I looked at it on pages 139 and 140 of the transcript, he gets up and he says, relevance, Your Honor. And the court's immediate reaction is there's no charge of possession of a weapon, which suggested to me the judge hadn't heard anything about it before. So if he had, that would be useful to me.
I stand corrected. I do believe the first mention of the gun is during the testimony at page 140. Be that as it may, that it wasn't addressed thoroughly prior to trial in a motion in limine. It was addressed at trial. There was a discussion. They went to sidebar, and the judge's decision to admit it in a case involving control is within the range of reasonable possibilities. While it didn't need to come in, that's not the question for the court. The court is whether the judge made a decision outside the range of reasonable alternatives. And I would suggest that she did not. The admission of the gun was probative, and the prejudicial value was relatively minimal. The way that it was presented to the jury, nobody argued that he was a violent guy who was using the gun in a violent manner. It was a controlling relationship, and that was how it was presented to the jury throughout. Are there any further questions on the gun evidence? Do Your Honor, if Your Honors have any questions about penetration, I can address those, or I would move right to the prosecutor's closing. The prosecutor's closing did not improperly vouch for the credibility of Michael Alessia, and it was a fair response to the defendant's closing. The defendant's closing states, I suggest there are a number of reasons why you shouldn't find Mr. Alessia was credible. And then for approximately a page and a half of the closing, the defense argues that Michael Alessia was not credible. The prosecutor then in her closing noted the detailed nature of the testimony for about a page a half a page, recaps the testimony, focusing on the detailed nature, and says, I suggest to you, ladies and gentlemen, that has the ring of truth. This is permissible testimony under Chavez, Chiampa. The prosecutor may make a fair response to the attack on the credibility of a government witness. And the prosecutor did use the rhetorical device of, I suggest to you, which has been cited with approval as a rhetorical device to urge the juries to draw inferences from the evidence. And there was nothing improper in the prosecutor's closing.
Let me ask you a question with regard to the instruction about the cooperating witness.
Yes.
The judge limited, I believe the judge instructed only that you should examine that witness's credibility with particular care in reference to the cooperating witness.
Right.
Isn't there a standard instruction or a model instruction that gets into a lot more detail about how a jury may want to view a cooperating witness's testimony with extreme care and caution?
There certainly is a model instruction. I mean, I would suggest that she's pulled out the essence of Chiampa by saying you should examine the witness's credibility with particular care, and then goes on to say, evaluating credibility along with other factors. She does say specifically that he testified pursuant to a plea agreement. The discussion of this instruction started with the judge. The judge said, I don't know if anybody has requested this, but I'm planning on giving this instruction. So nothing additional was requested. It was discussed the judge brought it up seemingly sua sponte. She said, I'm not sure if anybody has requested this. And it certainly gets across the gist of Chiampa. Whether there's a more detailed instruction that a party could have asked for, or the judge could have given, certainly, but I don't think that it was error, and certainly didn't impact the verdict.
Am I correct? There were no objections to the instructions?
Correct.
Okay, counsel, that's all I have. Justice Englander?
Yep, I'm all set, thanks.
Justice Hand?
No, thanks.
Thank you.
Thank you both. Well briefed, well argued, and the case is submitted. Thank you.
Thank you.
Thank you.
And counsel, number one, this case is being live streamed, so you are not only being captured live, but the case is also being recorded. And I will not remind counsel that this case is partially impounded, so please refrain from using names that are subject to the impoundment order. With that said, we will call counsel for the appellant, Attorney Kiley.
Good morning, and may it please the court. Rebecca Kiley on behalf of Jonathan Ramos. The issue before the court today is simply whether we raised in our motion for a new trial a substantial issue warranting an evidentiary hearing. And a credible claim of ineffective assistance of counsel is a substantial issue. It is an issue of constitutional dimension. Here, there were two grounds for a credible ineffectiveness claim. The first was counsel's misapprehension of the law of resisting arrest, which pervaded the entire trial. There were at least three errors related to this problem. First, he conceded all of the elements of resisting arrest, both in a pretrial proffer to the judge and in his opening statement. Second, he mounted two different but legally invalid defenses to resisting arrest. He defended the charge both on the basis that the officer had not told Mr. Ramos what he was being arrested for, and on a basis that is a valid defense in many states, but is not in ours, which is that there was no crime justifying the arrest. And finally, he failed to advise Mr. Ramos properly about the law of resisting arrest, which resulted in the defendant's own testimony, essentially conceding the charge on the stand, following his attorney's multiple concessions.
So as I understand your argument, it's that had defense counsel properly advised your client would not have testified, correct?
That's right.
So I'm having trouble reconciling that with the fact that your client did testify and was found not guilty of assault and battery on a police officer, was found not guilty on disorderly conduct. So why was this not a reasonable strategic decision? I mean, it seems like no good deed goes unpunished. Defense counsel eliminated two substantial charges with this strategy.
Well, it's not at all clear that he was strategically conceding the resisting arrest charge. And I think that's exactly the kind of issue that we would need an evidentiary hearing
Does
to determine.
Does the defendant's testimony simply that he pulled away from the officer and the officer fell down, as a matter of law, does that constitute resisting arrest?
It does under Commonwealth versus Grandison, because it creates a risk of physical injury to the
I
officer.
pulled away.
I'm sorry?
Just the testimony I pulled away means beyond a reasonable doubt. I mean, I'm struggling with that just as Judge Neyman is. mean,
I don't think I don't think the Commonwealth disputes that.
Depends on him using the words, quote, "I pulled away." Right?
Right. And I think, I mean, it seems quite likely that that was the basis for the conviction. The jury asked the question, does his pulling away constitute resisting arrest? The judge responded by reading.
Sorry to interrupt, but wasn't the officer's testimony to the effect that he pulled away? Oh, sorry, he didn't say pulled away, that he started punching me. He hit me. I had to pursue him. He hit me again. He tried to hit me. I continued to pursue him. I had to wrestle him down. It seems to me that that testimony right there already gets you past the required finding standard.
Sure, and this is not an argument about the sufficiency of the evidence, but my point is that it seems pretty clear that the jury largely rejected Officer Reeves' testimony. I mean, as you said, Officer Reeves testified
because they heard from the defendant.
Well, they also heard from the defendant's brother, who offered, all of the same testimony, except that he.
But I would say again, they may have rejected it because they heard from the defendant and not just from the defendant's brother. I think that's Judge Neyman's point. I mean, your argument depends on the assumption that he wouldn't have testified had he been. This part of your argument depends on the assumption that he wouldn't have testified if he'd been properly advised. But it seems to me that he had another charge to deal with.
Well, he did, but it is the Commonwealth cites, I believe, both Durakowski and Claudio, which are cases that recognize that a lawyer might make a strategic decision to concede a lesser offense in order to gain acquittal on the greater offense. That is not the relationship of resisting arrest to assault and battery on a police officer. Both of these charges are misdemeanor offenses that carry a maximum sentence of 2.5 years in the House of Correction. It's not, resisting arrest is not a lesser included of assault and battery on a police officer. He wasn't put in a substantially better position by conceding that charge. In fact, he spent a year in jail on this charge. But I think the bigger point is that the question of whether this was an intentional concession that was reasonable under the circumstances is very far from clear on this record, and that is why we needed an evidentiary hearing. I don't think we can
help me with that.
I'm sorry to interrupt.
The hearing would get into the state of mind of the defense lawyer to what end? I mean, is that an objective standard ultimately?
Well, the question of whether this was a strategic decision is a factual question that the defense counsel could offer testimony on. And I would submit, based on what I conveyed in my affidavit about the conversation that I had with him, I think it is unlikely that he would claim that this was a strategic decision. I think he would say that they were fighting all of the charges, right? Mr. Ramos makes it clear in his affidavit that it was important to him to be acquitted on all of the charges.
Right, but the strategic decision would be whether or not to have the defendant testify because he had a better chance of beating all the charges. Right? I guess.
Right, but if the defendant's truthful testimony compels a conviction on one of the charges, I think that changes the calculus, and that is what happened here.
Can I ask, I want to go back because you keep using the term concession.
Mm-hmm.
As I understand the third element of resisting arrest, it's that the defendant resisted by either using or threatening to use physical force or by some other means create a substantial risk of bodily injury.
Mm-hmm.
So merely because your client testified that he pulled away, couldn't a jury still have found that that did not constitute the use or threat to use physical force and that did not create a substantial risk of bodily injury? So in other words, I'm having difficulty with the notion that your client's testimony gave up the case. I just don't see that, but perhaps you can convince me.
That he testified that he pulled away and that the officer fell. And in Commonwealth versus Grandison, the Supreme Judicial Court made it clear that the act of pulling away can satisfy that third element of resistance.
And that speaks to sufficiency, which you've said is not what this argument is about. Do you follow my question?
I'm not totally sure that I do.
I think that once that's enough to satisfy a required finding of not guilty. But that does not mean that a jury as a matter of law would have had to have found resisting arrest beyond a reasonable doubt based on your client's testimony.
Well, I think if they believed it, then based on the instructions, they would have. And there certainly was not an argument made by counsel that, you know, that he pulled away, but that the slip was, you know, not caused by the pulling away, or that didn't actually create a risk of injury to the officer. And those were not the arguments that he was making. The arguments he was making were legally invalid defenses to the crime of resisting arrest.
Well, the arguments he was making may have been legally invalid, but they may have been darn good jury arguments, right? I mean, the jury can exercise lenity, and he's saying, hey, they didn't have any basis to arrest this guy. Come on, what's going on here? And then he pulled away. So what? Wouldn't you under those circumstances? What's this police officer doing? Why is that a poor argument?
Well, it just, again, he had his brother's testimony, which was essentially the same as his, except that the brother did not hear the officer tell him that he was under arrest. And so he could have relied on that. But if that was the strategy, then I think that goes to the second issue here, which I haven't talked about yet, which is his failure to obtain the medical records in this case. And counsel knew that Mr. Ramos had been hit in the head that night with a police baton, which the officer acknowledged is a potentially lethal hit. And he knew that he was hospitalized and his skull was fractured, but he did not get the medical records. So at trial, the jury heard from Officer Reif that the injury was just a gash, to which he administered some first aid before he went to the hospital. The ADA essentially mocked his brother when he described the blood gushing from from Mr. Ramos. And the ADA was totally incredulous about his claim that he had also been maced. And Mr. Ramos was not permitted to testify about his skull fracture because they didn't have the records. Had they had those records, it would have shown that the call was for a potentially dangerous hemorrhage, that his right frontal bone, his forehead essentially, was fractured into several small pieces. Surgeons had to remove some of that.
I'm sorry to interrupt you, but why on the evidence here would the level of injury to Mr. Ramos have made a difference in the officer's motivation to be truthful or not in his testimony?
Because the fact that he caused such a serious and substantial issue, such a serious and substantial injury, I think goes to his motive to claim that it was justified, even to falsely claim that it was justified. But I was partly responding to the extent that the Commonwealth here is saying, look, the best he could do here was ask for some lenity. If that's what he was doing, then he should have put these medical records in front of the jury, because I think if there was anything that was going to make them think like, oh, pulling away, did he really deserve this? It would have been learning that, you know, he had a titanium mesh net implanted into his forehead because of what this officer had done to him. He had a traumatic brain injury. And the other thing is the records do establish that he was in fact maced. And that was, you know, he was mocked for that by the trial prosecutor.
But doesn't that in a way backfire on your Grandison argument, where if the jury believes that he was maced, do they not also believe that, as he said, he pulled away? And isn't that enough?
The macing, he testified that he was maced after he was removed from the house.
Mm-hmm.
The jury instruction, I assume, said what the law is. It didn't say pulling away is enough. It said you need to use physical force, right? What did the jury instructions say with respect to what is sufficient for resisting arrest?
They recited the elements, and I could find them in the transcript. I'm sorry, I don't have that.
I'll look it up. I'm struggling with something that I was thinking when I came in here, but Judge Neyman has moved me off it, which is your argument suggests.
That's a first, by the way, so.
Your argument suggests, I don't know what to do with that one. Your argument suggests that that basically his testimony conceded guilt, and therefore we should find ineffective assistance of counsel. And I literally had in my head, well, why would we overturn a conviction where your client was guilty? But now Judge Neyman has pointed out maybe your client wasn't guilty on the way the instructions are given, what was needed to be proved. And I'm just not sure where that leads me with respect to your first argument.
I mean, again, I will be candid that I did not reread Grandison before this argument because I thought this was not an issue that was in dispute. I thought that the parties agreed that resisting arrest had effectively been conceded by the attorney and the client. But my memory of the case is that what it says is that when an officer puts hands on a client or not on a arrestee in order to arrest him and the person pulls away, that is sufficient. And again, I appreciate the difference between sufficiency and whether they had to prove it beyond a reasonable doubt. But that was, I mean, I think the key thing here is that the jury acquitted Mr. Ramos of all of the charges where they had to credit Officer Reif in order to convict him. And they convicted him of the one charge where his own testimony corroborated the claims made by Officer Reif.
So help me with this because I should know it, but I didn't see it mentioned. And I saw the mention of jury questions. Was there literally a jury question that said, is pulling away sufficient?
Yes. I mean, it may not have been, I'm paraphrasing.
How was that answered?
By, I believe, by a rereading of the elements of resisting arrest.
And did the prosecutor argue in closing, look, he admitted that he pulled away and that's enough?
I'm sorry, I can let the court know that in a follow-up letter.
Yeah, we can take a look. I'm just trying to get my head around where we are here.
But his concessions weren't necessary. He didn't understand them at the time that he made them. And I think that he has said that in his affidavit, and I think it is credible, right? That Mr. Ramos believed, consistent with what the law is in many places, and I think what a lot of lay people's common sense understanding would be, that if the officer had no reason to arrest him, that he was entitled to resist that arrest, that he could pull away, that he could struggle to get free.
And I have a question that is important, at least to me. If you are given an evidentiary hearing,
yes,
tell me what you would expect to get from the evidentiary hearing. What are the things you would expect to prove?
I think that we would hash out this issue of whether this was a strategic decision to concede the elements of resisting arrest or whether it was inadvertent and based on a misunderstanding of the law of resisting arrest. And secondly, I'm not sure that it's really in dispute that the attorney failed to get the medical records, but to the extent that the Commonwealth has not fully agreed with that on this record, I think we would also establish that.
Attorney Kiley, your time is up, but we have interrupted you several times. So if you would like another minute to complete your argument, feel free to take that time.
Thank you. I appreciate that. I believe I've covered what I needed to. Thank you.
Thank you very much. We'll hear from the Commonwealth.
Thank you, Your Honor. May it please the court, Carrie Kohler for the Commonwealth. The Commonwealth's position is that the trial judge, who was also the motion judge, did not abuse his discretion in declining to hold an evidentiary hearing. Given what was submitted with the motion, which was supported by the defendant's affidavit, counsel's affidavit recounting the conversations she had with trial counsel, and the civil attorney who represents, I believe, continues to represent the defendant in a civil case, there was no substantial issue raised that warranted holding an evidentiary hearing.
Counsel, do you disagree on the record before us that there's a substantial question about whether trial counsel for Mr. Ramos understood what the elements of resisting arrest involved?
No, I don't agree with that. What I'd suggest the record establishes, and also the conversation recounted by defense counsel's affidavit, is that something changed throughout the course of the litigation of the trial. Essentially, this case comes down to credibility between the defendant and trial counsel. Initially, the trial sort of developed as the officer is making this story up. It's unbelievable, it's incredulous. And when the defendant takes the stand and testifies, if if you also take that into consideration with what trial counsel said, he surprised his attorney. And in looking at the question posed to him by trial counsel, what we're calling a sort of concession, but really it's just his description of pulling away from the officer, was non-responsive. It was an answer to a question that wasn't being asked. It was important to the defendant that
Sister, correct that he had represented that already twice before. How is he surprised when he'd made the same representation twice earlier in the trial?
Well, I'd suggest that in looking at his entire, the sort of beginning part of the trial, which I'd say is different than the end, the defense attorney is sort of laying the groundwork for what the jury can expect to hear, and sort of saying, but it didn't actually go down that way. You're going to hear from the officer, and it's going to be a totally different story. And then after the defendant testifies, after his other two witnesses testify, the framework and the theme is essentially appealing to the jury about what had happened to this defendant, and that he was really the victim of what the officer had done to him.
Defense lawyer to know that his skull had been fractured? Wouldn't it have helped the jury to know that his skull had been fractured?
I don't think so. I think it was established on the record the attorney knew his skull was fractured. In this particular circumstance, I seem to recall there was a sidebar conversation about whether or not
I misasked the question. Yeah, the lawyer might have known, but he couldn't get the evidence in. Wouldn't it have helped him to have the medical records so that he could prove it?
I don't think so. The medical records are rather unhelpful if they're taken entirely as they would have been if they'd been admitted. It was clear the defendant was intoxicated. He lied about that on the stand and said he wasn't. At least one of his witnesses testified he'd never been drinking, and that was pretty clear from the medical records that he had been drinking and all day. The actual diagnosis of fracture.
Why is that clear? They had a serum level, right? What did the serum level correspond to?
I don't recall that, Your Honor. I didn't do out the count.
Say to me it's clear. I only know it's clear based on what the serum level would have shown.
I'd concede I don't know the answer to that, Your Honor.
Okay.
What I'd say about the nature of the injury is that the court was able to hear from the defendant, his witness, and they were also able to see that he had a scar on his head. They were in a physical position to actually observe that, which I
tell them that the force of the blow was so substantial that it literally crushed a portion of his skull, which is my understanding of what the medical records would have shown.
And they would have. I'll concede that. It was a very serious injury, and I'd also suggest the officer testified that was not an appropriate way to use his baton. It was not the appropriate area of the body to hit. I recall that he had testified he'd received training of the appropriate areas of the body that are targets for baton strikes, and that the head wasn't one of them. And he conceded that striking the head is a potentially fatal blow. So the jury had that information to consider before them. And I would suggest to the court that there's the medical records wouldn't have added much more beside that.
Would you agree? Well, let me ask the question this way. Attorney Kiley filed a comprehensive affidavit in support of a motion for new trial. And there are representations therein regarding her communications with trial counsel. And is it fair to say that her representation regarding those communications is inconsistent with the representations made by the defendant in his affidavit?
Yes, they are too.
So if that's the case, why should the judge not have held an evidentiary hearing to resolve those inconsistencies and make the necessary credibility determinations on a motion for new trial?
Well, the trial judge, who happened to be the motion judge, who also was a violation of probation judge, I submit was in the best position to evaluate credibility. And he was also free to discredit the defendant's affidavit. The full extent of the information is the defendant had a very strong interest in, personally, and he expressed that, he had a very strong interest in fighting the conviction. He represented information that was necessary to establish that.
I understand that, but did the judge make such findings of fact that he didn't find the defendant's affidavit to be credible?
He did not issue any findings of fact, Your Honor. But I would submit that he did not abuse his discretion in the circumstances. He did opine during the hearing, although he didn't make any formal findings and he didn't issue any findings orally. He took it under advisement after hearing, but he did discuss the ongoing civil suit. He did inquire, I believe, of the prosecutor.
At all relevant.
I'm sorry?
Why do we care? Why do we care that there's an ongoing civil suit?
I'd suggest that it demonstrates an interest of the defendant in challenging his conviction and creating a self-serving affidavit. And that would go to whether or not what he puts forth
because he's concerned that they might get in the conviction when he's testifying in a civil trial. I'm struggling with how important that would be.
I don't know that, Your Honor. And I don't necessarily know if that's what the defendant was contemplating. I do recall when I reviewed the affidavit, him averring that it was very important to him. And given that statement in light of his trial testimony, it seemed to be personally important to him that he not be convicted of resisting arrest, regardless of his guilt.
For most criminal defendants not to be convicted.
I'm sorry?
I'm struggling with the importance that it's important to him. Most criminal defendants don't want to be convicted. It's important to them not to be convicted. And after they've been convicted, even though they've served their time, many of them come before us and want their convictions overturned if it's appropriate.
I understand that, Your Honor, and I'm not casting aspersions on the desire or the want, but it is informative of the context of how this.
The fact that there's a civil suit is not informative, and I don't think there's anything in the cases or in the briefs that suggests that it is. We have a cop who hit this guy so hard he fractured his skull, and then he could not find, apparently for over a year, no one could find his records of that. So they weren't provided to defense counsel in advance, as they should have been. That's problematic for the criminal trial counsel.
I agree with that, Your Honor. I do recall the fact that is in the criminal case that the officer that I believe the prosecutor had inquired and was told that the materials did not exist. So as far as the trial prosecutor's work, I believe he exercised his duty to try and locate those materials.
Understood.
Thank you, Your Honor. If there's no further questions, I'd rest on my brief.
Yeah, Justice Englander?
I have nothing further. No.
Justice Hand?
No, thanks.
No.
Thank you.
Thank you very much for your comprehensive briefs and your arguments. We appreciate it. Thank you both very much.
All right, we are live.
And good morning. We are now calling our fourth case on the list, 2019 P1224, Philip Johenning and another versus Planning Board, the Town of Milton. And we will hear first from counsel for the appellant. And before we proceed, my understanding is that some counsel will be splitting their time. Can you tell us how much time each of you will need?
We've discussed splitting the time, and Attorney Freitag is we've agreed that I'll speak first and that Attorney Freitag will, if necessary, yield some of his 7.5 minutes so that I can complete my remarks. But we're planning on trying to split 7.5 minutes each.
Okay, thank you. Okay, we'll hear first from counsel for the appellant.
Thank you, Your Honor. Matthew Dunn on behalf of the appellants, Philip Johenning and John Rowe. Your Honor, the underlying case is a zoning appeal brought by Mr. Johenning and Mr. Rowe pursuant to MGL 48 Section 17 to challenge the decision of the Milton Planning Board granting a special permit to the defendant appellees, Thayer Nursery Corporation, F. Joshua Oldfield, Margaret T. Oldfield, in favor of certain residentially zoned properties in the town of Milton, pursuant to a specific section of the town of Milton's zoning bylaws, which is section 3A7, subsection N. The decision allows Thayer Nursery
Counsel, this
to
is Judge
engage.
Miller. Can you hear me when I speak?
Yeah.
Okay. We're familiar with the record, so let me, if I could, just cut a little bit to the chase.
Absolutely.
Do you agree that the individuals, the Oldfields, qualify under the 2016 Milton legislation, or whatever you want to call it, that allows for a special permit?
I don't, and I can explain to the court my reason for my position, which is I don't think that there's any dispute, and the majority of the facts in this case are not in dispute, that Thayer Nursery Corporation is the entity that has been operating the Thayer Nursery business on the subject properties going back to at least 2012 and likely well before that. If the court were to review the special permits that issued to Mr. And Mrs. Oldfield back in 1967 and 1987, they'll see that the rights that in those special permits could only be transferred to the individual members of the Oldfield family. And so Josh and Maggie Oldfield are the children of the Oldfield parents. Those rights transferred to them.
Right, but let's talk about the 2006. I understand the point, I think, but the 2016 bylaw itself says that they may grant a special permit where there was a landscaping business being conducted in July of 2012, and the applicant or applicants or their predecessor in interest on that date held a special permit. Now, didn't both of the Oldfields on that date in 2012 hold a special permit, the one that was granted in 1987 at least?
Well, I think that there's an issue for the court to decide with regards to whether or not those rights had lapsed under 40A.
Was that issue
Section
raised
9.
before was the lapse issue raised before the lower court?
Yes, it was, Your Honor. It was raised
How was
during
it argued? Because I don't recall her addressing it at all.
It was, I believe it was argued, it was presented during oral argument at the motion hearing for the summary judgments that are now before this court.
So it was presented at oral argument. Was there an argument made to her before that a lapse had occurred and that therefore they did not hold permits? Was there anything in the briefs? Were there any facts presented?
I'd have to go back to the actual briefs that were presented to the land court. I'm not sure of that answer, Your Honor.
Would you agree with me that if no facts had been presented to the lower court about lapse, then it was appropriate, at least with respect to these two applicants, the Oldfields, to conclude on the summary judgment record that they qualified under the 2016 bylaw?
Well, respectfully, Your Honor, I believe that facts were presented to the land court with regards to what entity operated the landscaping business on the subject properties.
The argument
So
has to be made.
the fact, the argument, again, Your Honor, the argument was made to the land court during oral argument on the motion for summary judgment. And that argument was based on the facts that were included in the record before the land court, which is that Thayer Nursery Corporation and not the Oldfield individual members operated the landscaping business on the subject property. And, you know, we would argue that that operation, even going back that far, was illegal as against the zoning bylaws for the town of Milton.
Council, could I ask a question? What's the significance of the including any assistance language?
I don't know what the significance of that is. I can tell you that Thayer Nursery Corporation certainly isn't an assistant of Maggie and Josh Oldfield. Thayer Nursery Corporation is the principal operator of the business that's being conducted on that premises.
What
They're not
evidence
assist-
that was put in the lower court?
I'm sorry, I didn't catch that, Your Honor.
Again, I don't want to cut off Judge Hand's question because it's important. But you say that they were the principal operator. You say that in your briefs, but I don't get the sense that that evidence was presented to the lower court.
I think, respectfully, Your Honor, I think it's all over the record of this case that there's admissions on Thayer's side, there's admissions on the town of Milton's side, that Thayer Nursery Corporation is the entity that's conducting the landscaping business on the subject properties. It's not Maggie and Josh Oldfield. I mean, I think that there's.
But how would we even go about, and we being the wrong question here, because I'm stuck on the fact that Judge Rubin would have had to go about concluding that it was Thayer Nursery Corporation as opposed to the Oldfields that were conducting the business, because the Oldfields, by all accounts, were also on the premises every day.
As employees of Thayer Nursery Corporation. And that's in the town's brief, and that's in the Oldfield appellee's brief as well, that there's an existing corporation that Maggie and Josh Oldfield serve as officers or directors of that corporation and also as employees of the corporation, and that the corporation is the entity that operates the landscaping business on the properties.
But you use the word operate, and I think, how do I know that what is the legal framework for determining that the corporation is, quote, the operator, as opposed to Maggie and Josh Oldfield, who are the principals of the corporation? I mean, you have this argument of lapse that kind of appears out of nowhere halfway through your brief. And I'm stuck with what evidence, what legal framework, how do we decide that lapse could have occurred? It's very hard to get my head around under the current state of the briefs. It may be appropriate, I think, to move on to other aspects of your argument.
Okay, and I'm happy to do that, Your Honor. The primary argument that's advanced in my papers is that Thayer Nursery Corporation does not satisfy the eligibility prerequisites of the bylaw amendment in which the special permit was issued. As the court's aware, there is specific language with regards to prerequisite eligibility for that zoning relief that's provided in the bylaw amendment. And of particular concern to Mr. Johenning and Mr. Rowe is the requirement that the applicant or applicants or their predecessor in interest held a special permit pursuant to subsection 3A7D or use variance on July of 2012. I don't think that there's any dispute that Thayer Nursery Corporation did not itself hold a special permit or use variance in July of 2012.
Well, if it's been operating since 1967, as you say, then why wouldn't we deem it to be a permit holder as of that date?
Because the permit ran to Robert Oldfield and his wife.
So that's an argument that elevates form over substance to the nth degree, because it suggests that the town of Milton in 1967 didn't know what they were doing when they granted that permit. They granted it to the wrong people.
I don't think that that's accurate. I don't think that there's anything in the record that indicates why is it not accurate?
Well,
because
in 1967, they wanted to permit the nursery business. And you're saying they gave it to the wrong people because Thayer Corporation was the corporation that was actually operating the business and therefore the ones who should have gotten the permit.
I think that Robert Oldfield and his wife were the individuals that were operating the business, doing business as Thayer Nursery Corporation. I think that's
the exact opposite of what you just told me about 3 minutes ago, counsel. I mean, if they're operating the business, they're operating it now, aren't they?
Maybe I can bridge the gap here. In 1967, I think that the court has to understand that there's been a metamorphosis of the business activities on the property. In 1967, you had a husband and wife operating a nursery business in a residential district. Over the course of years, and I've said this before to the court, Thayer Nursery Corporation is a bit of a victim of its own success. It's grown exponentially, but kept the same location in this residential district in the town of Milton. And so as the nursery business shrunk, the landscaping and construction business grew. And Thayer Nursery Corporation basically stepped over the operation of the mom and pop nursery that was operated on the premises and became a corporation operating a large scale business on that premises.
Okay, but that's an argument about growth. Let's go back to 1967. In 1967, was Thayer Nursery Corporation in existence at the time that the permit was granted to the Oldfields?
I believe that that Thayer and the Oldfield has presented evidence in the record that it did exist at that time.
So
So
help me, why am I wrong then in asking the question, why didn't the original permit go to Thayer Nursery Corporation if it was already operating in 1967?
I can only speculate as to the Zoning Board of Appeals intent in drafting the 1967 and 1987 permit in the way that they did. What I can say is that there are specific, plain, unambiguous language in both of those permits that indicates that the zoning relief afforded to it only runs to the individual members of the Oldfield family. And so what Thayer has attempted to do, Thayer Corporation, is piggyback on those non-transferable rights in order to basically shoehorn themselves into the eligibility requirement of the bylaw amendment that's before the court.
And so your argument hinges on the notion that Thayer is not a successor in interest, correct?
That's correct, because they can't be, because that's specifically precluded in both the 1987 and 1967 permits.
What about Josh and Maggie? Are they successors in interest?
Josh and Maggie are successors in interest under the language of the bylaw.
But you're saying that they're not applicants.
Special permits. Yes, they are. And so the issue with them is with regards to the issue of lapse that we've talked about previously.
Understood.
So the court's aware of the language that's used in the bylaw amendment. I think that some time should be spent to the purpose of the bylaw amendment. And these aren't my words. These are words that are presented to this court by the town of Milton in a prior appeal concerning the very same bylaw amendment. The purpose, according to the town, is to provide an avenue for any person or entity who can satisfy the eligibility prerequisites of the bylaw amendment with the means to obtain a special permit that allows them to operate a landscaping business in a zoning district. And this is from the town's brief in a prior case. The zoning amendment simply creates an opportunity for landowners in residential zoning districts in the town, which meet certain criteria, and that criteria is the eligibility criteria that's set forth in the amendment, to apply for a special permit to resume operation of a landscaping business, which is in the public interest for the town of Milton. There is no assurance that such a special permit would be granted. And if granted, it would be subject to conditions, and thus the public welfare is protected by the zoning amendment. Now, applying what I've found with regards to the court's interpretation of the bylaw amendment, obviously it's a question of law for this court that's governed by the familiar principles of statutory construction. And it's my understanding that the court is to first look at the ordinance's language, and if its meaning is plain and unambiguous, the plain wording shall be enforced. And in those situations, it does not consider the legislative history or agency interpretations when the meaning of the statute is clear. It's our argument that the court does not have to look any further than the language of the bylaw amendment itself, and particularly the eligibility prerequisites that are set forth in that opening paragraph. The corporation, as I stated before, doesn't hold its own special permit and didn't hold its own special permit or use variance in July of 2012. And it was a predecessor in interest to the rights in the special permit held by the individual members of the Oldfield family because the 1967 and 1987 special permits specifically precluded any such transfer outside of the Oldfield family. The corporation is a separate and distinct legal entity that would need its own eligibility with regards to having rights in a special permit or use variance in July of 2012, and it simply didn't have that. And so
Mr. Dunn, I'm sorry to interrupt you, but your time expired about 30 seconds ago. If you'd like to very briefly sum up for 20 seconds, that's fine. Otherwise, we are very familiar. We've read the briefs and the materials.
Thank you, Your Honor. The only last point that I'd like to make, and I'll do it briefly, is that the land court relied on the planning board's findings with respect to Thayer Nursery Corporation's eligibility. And there was no findings that were made in the underlying decision that issued before this court. So with that, thank you very much, and I appreciate your time.
Thank you very much, and we'll hear from counsel for the appellee.
Good morning. I'm Marion McKettrick. I represent the Thayer FELIZ, and our argument is that the planning board properly determined that Josh and Maggie Oldfield and Thayer Nursery were eligible to receive this landscaping permit. I'd like to provide some historical background briefly. I think it helps to explain and respond to some of the questions that have been raised. Milton zoning bylaw in section 3 describes allowed and permitted uses in residential districts. The nursery bylaw 3A7D allows nursery use on acreage of less than 5 acres, and the only requirement is that produce be cultivated on the premises. By 1967, then in 2014, the town meeting enacted 3N, which is an additional use provision or subsection. It's not a subsection of 3A7D, and that provision allows landscaping use in residential districts, but with many more conditions and restrictions on that use than the type of nursery use allowed in the nursery subsection.
Counsel, I think your time is short, and I'd like to, if you don't mind, interrupt and get a few things straightened out that are troubling me. Was the issue of lapse raised in the land court?
It was mentioned in oral argument. I was not aware. I do not believe that it was discussed in any of the memoranda submitted. When it was raised in oral argument, I responded by saying that there had never been lapse, that the permit continued to be effective, and that the Board of Appeals continued to make findings under the permit as recently as 2014.
And I appreciate that answer. And I also would add, I would add to that I assume the issue of lapse was never raised before the planning board.
I'm not aware that it was.
And
I didn't represent the defendants before the Thayer.
What are we reviewing here?
Yeah.
We're reviewing the decision of the land court, but it traces back in some way to the decision of the planning board, right? The planning board is the one who granted the special permit. If the issue of lapse was never raised at any time before the planning board, it seems to me that's significant.
I think it's significant. I don't believe that lapse is properly raised at this point. And I also, there is no lapse. There was no lapse. The arguments that the appellants have raised to support their lapse, their position that there's lapse, are based on their arguments that the corporation isn't an eligible recipient of the permit.
Okay,
but
but
the permit was violated. You know, I mean, it's just.
No, but you can't, no, we need to take the lapse issue as if the corporation is not a proper recipient.
Okay.
So that's the principal argument. Let's get to that if we could. And let me ask you this.
Mm-hmm.
As to the corporation, your position is the corporation should become it should be affirmed that they are a special permit holder. Is that right?
Yes.
Have they ever been a special permit holder before 2016?
I believe that when the special permit was issued for nursery use, it was issued with conditions that it could not be transferred from the Oldfield family. In 1967, the Board of Appeals was very concerned about maintaining control by the Oldfield family. They would have known that Thayer Nursery Corporation existed and that it was a corporation controlled by the same two persons that were going to
that doesn't help me
receive the
very
permit.
much. I mean, a corporation is a different entity than the Oldfields, right? In law.
Yes,
Okay. And the applicants in 1967, according to the document that I've seen, were the Oldfields, not the corporation.
yes.
Okay.
And it wasn't important for a nursery permit to define the business. Nursery,
Well, but it was very important, apparently, in 1967 for the town of Milton to say this runs to you personally.
right. They felt that the
Personally, am I misreading that when I think personally means not any other entity?
the permit runs to the Oldfields and their assistants. It could be used by their employees, and their employees were employees of the corporation. The corporation was controlled by the same two Oldfield individuals to whom the permit was issued.
But you're not suggesting that whoever was assisting them in 1967 also received a special permit, are you?
They had the right to operate under the permit, but
Because
that
they were
permit could
assisting
not be, had to be
because they were
controlled by the
assisting permit
Oldfields.
holders.
I'm sorry?
They had a right to operate in 1967 because they were assisting the permit holders, but they did
Yes.
not thereby become permit holders.
No,
So here's the question, because I do think substance matters.
Mhm.
If your argument is sustained and the corporation in 2016 is appropriately granted a permit, can't the Oldfields sell that to whoever they want?
no, because there are conditions in the permit that say that the permit cannot be transferred, the land cannot be
Right,
transferred.
but Thayer Corporation then becomes a permit holder, and it's not being transferred, they're simply selling the company.
Thayer Nursery Corporation holds a permit with Maggie and Josh Oldfield. All three have to continue to hold the permit. If the corporation, but yes, the corporation could change its ownership, but Maggie and Josh and the corporation would have to continue to hold the permit. And
How
if they
do I
didn't,
understand that? Where does it say that?
there are conditions later on in the permit that say that Josh and Maggie Oldfield must remain as principal operators of the business, that Josh, Maggie, and Thayer Oldfield are joint and severally liable for upholding the conditions of the permit, that the permit cannot be transferred, and that the land cannot be transferred. These are all components of.
Sorry, counsel, I did read it, and so I really need to focus on the particular language.
Yes,
If what you're saying to me now is not the way I read it, so I need to understand it. It says the permit cannot be transferred, but if Thayer Corporation, the ownership of Thayer Corporation is transferred, there's been no transfer of the permit. We just have a new owner of Thayer Corporation. You're saying to me that can't happen because the way you read the permit, it requires that Maggie and Josh also be operating the business. Where are you getting that from?
I'm not saying that the corporation cannot be transferred. I'm saying that Maggie and Josh have to continue as principal operators.
And that was the question I just asked. Where are you getting that from? Where in the permit does it say that?
There's a condition in the permit that Maggie and Josh Oldfield must be the principal operators.
Counsel, I'm sorry, your time has expired, but you can complete your answer to the question, and then I have one brief question for you.
Well, that's the specific language. There's a specific condition in this permit saying that.
So you are saying that there is a successor in interest here, is that correct?
Yes.
So just answer this question for me, just a fundamental question. and I'm looking for a very concise answer. Under what specific legal theory or authority can Thayer be a successor in interest here?
I'm looking at the language of the bylaw, which has a statement of purpose and has criteria for eligibility. You have to read the statement of the criteria for eligibility to be consistent with the statement of purpose. The statement of purpose is, and this is very important when this bylaw was written, only existing landscaping businesses operating with valid nursery permits or use variances could receive this permit. And the ongoing operation is the language used in the bylaw. Ongoing operation is a term that describes the way the business operated in 2012. The way this business operated in 2012 and in 1967 was that the old fields were the principal operators. The business was Thayer Nursery Corporation, and the old fields controlled the business because it was a closely held corporation.
That's clear from that's all very clear from the record. So to answer my question, though, your legal authority is you're directing us back to the bylaw.
Yes.
Okay. Thank you. We will hear now from Mr. Attorney Freitag. And Attorney Freitag, I saw that you wanted to yield your some of your time, but we did give your co-counsel a few extra minutes there to answer. So we will now hear from you. You will have full 7 minutes.
Thank you very much. Again, my name is Kevin Freitag. I represent the town of Milton. And the most important word in Milton's brief and in our argument is purpose. It's the purpose for which the 2014 amendment, later amendment in 2016, was made. The purpose was to permit the ongoing operation of landscaping businesses that were in operation in Milton in July of 2012. That was necessary because of a decision from the land court in 2012 that said that, or had the effect of no longer allowing landscaping businesses like Thayer to operate in Milton without a variance. And the town of Milton reacted to that by way of a citizen's petition, which is no easy task, to change the bylaws to allow businesses like Thayer that had been operating for some time in Milton to continue to run their family businesses. And that's exactly what's happened here. And I think that that's the big picture. That's the most important part of this from Milton's side, from the planning board side, is that this was a very intentional decision of the town of Milton to protect businesses within Milton. And it was carefully thought and considered by the planning board in its application to Thayer when it granted the special permit in this case. The justices have asked some very pointed questions today about who held the special permit and who were successors in interest. I just would like to address 2 things on that. First, the children, Maggie and Josh, they weren't successors in interest. They were parties in interest pursuant to the 1987 amendment. And regarding the question of whether or not Thayer was holding a special permit, I would suggest to the court that it was implicitly through the special permits that had been granted to this business since 1967.
Well, no, but the special permits are granted to someone who is called an applicant. And Thayer Nursery is not an applicant on 1967 or 1987 permits, is it, counsel?
No, it is not.
And it's not named as a permit holder in 1967 or 1987, right?
That's correct.
Okay, so help me here with your sister's answer to my question. If someone sold Thayer Nursery Corporation is now identified as an applicant and therefore a permit holder in 2016. If the Oldfields decided to sell Thayer Nursery Corporation, what would prevent that?
The sale of Thayer Nursery Corporation, I believe, would be prevented by, if nothing else, the language that's in the permit that was issued, which suggests that the holder of the permit And the running of the business, Thayer Nursery, has to be done by not only Thayer Nursery, but also by the children. To your
Okay, so
point, I'm
where
not
is
sure that there's any.
I keep reading, it's a long permit. And you're probably a lot more familiar with it than me, counsel. You may have even signed it. But I can't find where it says that. And I don't think it was pointed to in our briefs.
I don't have that specific site for Your Honor.
Okay.
Perhaps Attorney McKettrick can find it while I'm speaking and have it by the end of the argument.
Thank you.
But certainly your point is well made that the nursery itself is never specifically identified as being an applicant, but it is mentioned every step of the way since 1967 as being intricately involved in the running of this business. And again, that's the purpose of the bylaw, is to save businesses. Thayer Nursery had existed for almost 60 years before 2012 when this special permit was granted. It has been in existence that whole time.
I'm sorry, counsel. It's not mentioned in 1967. It's not mentioned in 1987. I do not see the word corporation anywhere in those permits. Am I? No. Again, I would be glad to be pointed to it. That would be great.
Yes, with regard to the 1967 amendment, you're correct. It's not mentioned there. My point there is that the business itself was incorporated in 1965. It's not mentioned specifically in the special permit. In the 1987 permit, page 8 of my brief, there's a quote. The applicants have operated a nursery business known as Thayer Nursery.
Aha, thank you. Where's that?
That's page 8 of my
Yes,
brief.
okay,
Record
there it is.
appendix.
So it is in 1987. Thank you. Yep.
Yes. So again, that goes to the point that for quite some time, everyone understood that business was Thayer Nursery. And to my brother's argument regarding the distinction between the two, nowhere in the special permit or in the bylaw does it say that there's any sort of restriction on the way that these applicants are allowed to run their businesses. And so the argument that's being made by the appellant here is that, well, it's the children can't have it because they haven't been running a business in a long time, despite the fact that they're there every single day running the business. And the business that they run can't have it because that's not the children. So it just completely decimates the whole purpose of the amendment. The whole concept of let's try to save some family businesses here in Milton that have been around for 60 years. It just pulls that all apart and dives down into the minutia and avoids the purpose of the bylaw.
Unfortunately, counsel, and that argument is to me quite powerful, that if counsel were to succeed on both ends of his argument, both that the corporation should not be a permit holder and that the children's have lapsed, he would achieve what is clearly contrary to the intent of the town. But there is this other issue, which is the intent of the town in 67 was not to have the Oldfield sell this to someone else. And so I'm stuck on this concern that if the corporation is properly identified as a holder, then the Oldfields could sell. Now, I suppose it's limited because the permit's only 3 years long, it looks like to me. But that, I think, is an issue that's real.
I'm sorry, Attorney.
Patrick, we can't hear you.
So we're going to let Attorney Freitag answer that question. Go ahead.
I would actually, I think Attorney McKettrick may have a more pointed response to that. I would thank the court for its time today and rest on my brief and yield whatever remaining time I have to Attorney McKettrick.
We really don't yield. We divide time in this court. Justice Englander, if you would like a response from Attorney McKettrick, we can allow it. So
I wouldn't mind, Judge.
Yep. So if Madam Clerk, if we can turn on the sound for Attorney McKettrick, please.
Your sound is on.
Okay, go ahead.
In my brief on page 11, I described the 3 conditions in the special permit issued in 2016. And I reference the location of these texts at the record appendix. Record appendix 1, 40, 41, 43, 44, and 46. These are sections 7, 3, 9B, and 12 of the permit decision. Now, it's a long decision. It's very hard to find the sections in that decision, but the reference is in my brief on page 11. And these are the conditions: that there shall be operators, and the operators shall be Joshua Oldfield and Maggie Oldfield. That in the event the property or landscaping business shall be transferred to a third party and the party shall seek its operation, they will need to file a new application for a new permit, and that the named applicants are jointly and severally liable for any violations of the special permit.
Okay, thank you.
Thank you all. Thank you for the arguments, and I'd like to thank all parties for their helpful briefing in this case. Thank you very much. The case is submitted.
Thank you.
Thank you.
We are live.
Okay, good morning. Call the next case, 2019 P 971 Wildlands Trust versus Cedar Hill. Just to remind council, normal appellate court rules are in effect, so 15 minutes per side. There is no rebuttal. And of course, this case is being live streamed, so you are being carried live, and as well, it's being recorded. And with that in mind, we will hear from counsel for the Appellant Wildlands Trust.
Good morning, Your Honors, and may it please the court. Emily Canstrom Musgrave on behalf of Wildlands Trust. I'd especially like to thank the court for hearing us today by video conference. This case is about 12 acres of pristine land in Duxbury, which is protected by a conservation restriction, a special creature of contract in which the holder, here Wildlands Trust, accepts the onerous responsibility of protecting the land in its natural state in perpetuity for the public benefit. The trial court ignored the plain language of this restriction, articulating the wrong standard and eliminating the requirement that noticed violations must immediately cease. These legal errors not only hamstring Wildlands Trust in its efforts to preserve this land going forward, but also affect conservation restrictions being administered across the Commonwealth.
Okay, so let me interrupt you there. I just want to let council know that we have read the immense record on this case, and as well as the outstanding briefs, and we are more than familiar with the issues. So I'd like to cut to the chase. And it strikes me that this is strictly a contract construction case. However, the parties disagree at some level as to how to approach the interpretation of this contract. And it seems to me that Wildlands Trust is saying that although we use the rules of contract interpretation, we must analyze the restriction with a narrow focus, if you will. What is your best authority for that proposition? Because I was looking, for example, at the Chatham Conservation case, which says that a restriction like a deed is to be construed so as to give effect to the intent of the parties. I'm sure you're familiar with that language. Tell me why we should apply a specially narrow interpretation to this restriction.
Certainly, Your Honor, two reasons, one which I would anchor in case law and the other which I would anchor in the purpose of a conservation restriction generally, and this one specifically. So beginning with the case law that we would cite for that proposition, that's found in the Weston case, which has been cited many times since then and by both parties in their briefs. And that's the language that a restriction must be construed beneficially according to the apparent purpose of protection or advantage it was intended to secure or promote. And that's page 661 of the Weston case. But more importantly, focusing on this case, this restriction is drafted in a manner that is narrower than most restrictions, narrower even than the restrictions in Weston or in the Chatham, the Farber case that Your Honor was just discussing, because this restriction prohibits all activities on the land unless they are expressly permitted. And
so you're
that's
really
the
telling
inverse.
us to look, I'm sorry to interrupt, but you're really telling us to look to the plain language of the contract. Or yes?
Yes, Your Honor, I'm absolutely telling you to look to the plain language of the contract, and specifically regarding our argument as to the application of the standard here, that's found in Section 3, which in turn references Section 2. And so based on the plain language of this contract, the argument is that there is no quiet enjoyment standard that applies to the fee-generating activities referenced in Section 3.
The plain language of the statute, I'm sorry, the plain language of the contract, I have difficulty with the concept that this blanketly prohibited all uses and then made exceptions. In the second sentence of the purpose, grantor intends that this conservation restriction will assure that while permitting uses described in section 3B. I mean, you know, it's telling us up front, hey, you're going to be able to use this land.
Certainly, Your Honor, there are certain ways in which this land can be used, and those are carefully delineated in section 3B, but that doesn't override the general prohibition on uses of the land, and specifically for fee generating activities, which is really what's at issue here. If Your Honors look at section 3B3, that is the only subsection that allows for fee generating activities, and it applies quite narrowly to classes, conferences, and retreats consistent with the capital P purposes all described in section 2 above. There's no other reference to fee generating activities happening anywhere else in the contract.
So can I stop you right there? So 3B3 is limited, as you said. Fee generating activities are limited to classes, conferences, or retreats. So if someone pays a fee, or a group rather pays a fee for a retreat, can the participants in the retreat go kayaking?
It would depend on whether their kayaking, Your Honor, is consistent with the two purposes that are outlined in section 2. So is that preserving and promoting in perpetuity the bird, plant, and wildlife populations on the premises? And I'm not an avid kayaker, but I would assume that there are different ways that one could enjoy that activity. And what these conferences, classes, or retreats were designed to do were to allow, for example, for, I would say, a society of ecologists to come explore the flora and fauna and to look at them. It was not designed to allow for the churning hospitality industry, which is currently being run on the land, and which is the problem.
What is the evidence that you had a churning hospitality industry? I saw a reference in the briefs to something like 1,100 days in 7 years. Was that evidence in the record?
Yes, Your Honor, I believe all of that evidence was in the record, particularly through the successive notices, some of which were considered to be proper notices within the restriction, some of which was more of a dialogue back and forth.
I want to focus specifically on how often this was used and for what purposes. So am I to understand that somewhere in the record, not mentioned by the judge apparently, we will find that the other side admits, or that you proved, that there were 1,100 days of paid use of these premises during the 7 years from 2010 to 2016 or 17?
I can't point the court to a record site for that, but I do believe that that would be in the record, especially with respect to the summary judgment filings that were made before the same judge who then presided over the bench trial. And I also think that there's evidence in the record describing the ongoing nature, and certainly in the letters that were exchanged between the parties, of the way in which Cedar Hill is promoting and advertising its availability as a resort.
All true, counsel, but you know, there's this burden of proof difficulty, which I want to leave to this one side for now, the question, the legal question of where the burden stands, and just say the judge didn't seem to think that you'd shown him a lot of evidence of use. He identified about 5 or 6 specific instances of corporate retreats. He identified very few uses as a family retreat. And I'm trying to reconcile his view of the evidence you presented, because I did not read, Judge Neyman probably did read the entire thing, but I did not read the entire record. Trying to reconcile that with this notion that there were 1,100 days of paid use. It seems to me that's a lot of use if it's really in the record.
Yes, Your Honor, and I will set aside, to the best of my ability, the legal argument on burden, but it is related here because part of the problem is that Wildlands was precluded in the course of discovery from obtaining some of the records of each of those particular uses. And had the burden been on Cedar Hill instead to show that it came within that exception, more of the evidence that Your Honor is describing might be more
you
apparent.
maybe come a few bars of this, but you did not raise a discovery issue in your briefs. But why would you be precluded from finding out how they used the property? And how is it that you were?
There were discovery issues, Your Honor, with respect to guest registers. I believe there were Google calendars at one point that were at issue in deposition. And you might see reference to some of this in the court's summary judgment opinion as well, where I think there's a footnote that talks about what ultimately became a spoliation argument with respect to those records, in which Wildlands Trust struggled to obtain enough information to show exactly how many days the rentals were took place during those years. But I do believe that there is support in the record for the number that Your Honor cited, which is, as Your Honor says, a strikingly high number of days for a property that is supposed to be about preserving the land and not supposed to be about a hospitality enterprise.
Was there information about what specific activities were conducted during those 1,100 days that ran counter to the preservation and protection standard?
To the extent Wildlands was able to obtain information, there was some. Some of that included families who, for example, rented the land as a vacation home, essentially, left the property to go to the mall, left the property to do other types of activities, but were staying on the land.
What were they doing on the land? If they were bird watching and sunbathing, why is that a problem?
I don't believe there was evidence that they were necessarily bird watching or sunbathing.
I'm speaking hypothetically. I mean, there has to be some information at least as to what they were doing.
Yes, Your Honor, but I think the hypothetical is exactly the problem, which is that in this case, because the court issued a declaratory judgment, that governs the parties' relationships going forward, frankly, in perpetuity. This isn't a commercial contract where if the relationship sours, one party can walk away. And what the court has done is articulated a standard, this quiet enjoyment standard, which is arguably broad enough to encompass nearly any activity.
Did actually appear in his declaratory judgment?
Quiet enjoyment, yes, it does under subsection B of the final judgment, Your Honor.
He was actually parroting the language of his findings from the summary judgment decision, if I'm not mistaken.
That's exactly right. It's a little bit different. It's not verbatim, but it's quite similar. And it says, if I may read for the court from subsection B of the final judgment, allows classes, conferences, or retreats, including religious retreats as well as purely secular retreats, that at least in material part involve or promote the preservation, protection, study, or quiet enjoyment.
Enjoyment. So he doesn't make quiet enjoyment. He hasn't taken quiet enjoyment in that clause and turned it into a requirement. What he's done is he's trying to understand, and I don't blame him, what that language is all consistent with. And this is his effort at it. At least in material part involve promote the preservation, protection, study, or quiet enjoyment. What's wrong with that? Why isn't that well, let me back up for 1 second. Do you agree that the language all consistent with the purposes is ambiguous?
No, Your Honor, I don't agree that consistent with is ambiguous. I wouldn't say that there's ambiguity in this contract. If there were and extrinsic evidence were to be taken into account, then I think there would be a very good argument that thinking about the purpose of a conservation restriction for preserving the land would weigh in.
No. We're not going to say it's quote unquote preserving the land. We're going to go back and do what we're supposed to do, which is read the purposes identified in section 2. And those purposes are very hard to figure out because they seem to come at me in multiple waves, right?
Going back to Your Honor's point about adding the or quiet enjoyment, the problem isn't that quiet enjoyment becomes a limiting factor. The problem is that quiet enjoyment becomes an expansive point whereby things that might not previously have fallen within the capital P purposes of the restriction now might. Is there an argument, for example, that a retreat—
Quiet enjoyment of the bird, plant, and wildlife populations.
Precisely, Your Honor. And the concern is that would it be enough, for example, for someone in the course of a 3-day retreat to at one point look out a window and see a bird and say, now I've enjoyed the bird quietly, and therefore the use of the property is permissive. I see that my time is nearly up, and if I may, I did just want to get to the second point, which is the immediately cease point, which is that this conservation restriction contains a built-in injunction which requires Cedar Hill to immediately cease its activities upon notice from Wildlands Trust. And the judge here read that out of the restriction, which is problematic, notably because the land can be damaged in the interim, and that's why this restrictive provision does exist.
If, it's a big if the judge is correct that there was no violation of the conservation restriction, what happens to that argument?
If the judge, what we would say, Your Honor, that the failure to immediately cease is itself a violation of the conservation restriction, and that in and of itself would be enough to require reversal and certainly award of attorney's fees for Wildlands Trust.
Why would we reverse if there were no other violations except that they didn't immediately cease and desist something they didn't have to cease and desist?
We would say, Your Honor, that they did have to cease and desist.
I understand your point, but you understand mine as well.
I do, Your Honor. The answer would be that it's because the immediately cease requirement is itself a violation of the conservation restriction, and had Cedar Hill immediately ceased the noticed activities, Wildlands would not have been forced to file suit. I'd also add to my previous point that this is an ongoing relationship, one that will be affected for many years to come. So that immediately cease requirement may become very important going forward as well, and we'd ask the court to take note of that.
The judge was troubled, counsel, because there were positions taken as to what the restrictions were that were obviously overbroad to the point where you had to concede at closing of the trial that they weren't right.
Let me just stop you right there. Your time has technically expired, but in light of the many interruptions in the expansiveness of this of the record here, so long as my co-panelists agree, we're going to give you more time, and Attorney Morgan, we will give you additional time as well. So please answer Justice Englander's question.
My apologies, Your Honor. Could I have that question one more time?
Well, really, it was, I mean, the judge was concerned that early on positions were taken about how restrictive this was, that it had to be for religious or charitable purposes, and that anything that wasn't for a religious or charitable purpose was invalid. And he was concerned that given those positions that you'd taken, the fact that they continued to operate didn't strike him as being unfair. And in fact, it struck him, I think he used the word, well, he used some pretty strong language directed at your client. I mean, isn't that a legitimate concern that the judge had?
The question is whether there was a legitimate concern that the position was initially overbroad.
Right. I mean, I'd like you to address the problem. If you construe the language as strictly as you want us to, you could stop them from doing things that are clearly appropriate. And that was his concern, which he articulated from the bench.
I understand Your Honor's question, and I do understand the point, both from trial and now. What I would say is there is no evidence that Wildlands Trust, a nonprofit, was taking a position that was unfair to Cedar Hill, that was in any way in bad faith. I certainly think there would be good faith implied in a restriction, even under these circumstances. And I think it was appropriate that as time progressed, as trial progressed, that Wildlands Trust was able to focus on the two notices, the February 2016 notice and the May 2017 notice, which noticed activities that were problematic because of the legal errors that now come up, the quiet enjoyment standard, the failure to immediately cease, and this waiver issue, which we haven't discussed, but which is in the parties' briefs as well.
I'd like you to address the burden of proof issue. And my first question regarding that issue is, was it properly preserved for appeal? I saw after the judge issued his findings of fact and rulings of law, counsel then lodged an objection, and the judge said, yeah, you know, we mentioned that in closing and the record is what it is, basically. Can you point me to where in the record we can find this preserved prior to the judge issuing his findings of fact?
That is the only place that it appears in the record, Your Honor. I would take the position that's sufficient to preserve it, but it doesn't appear elsewhere in the record.
Well, because then you have trial proceeding along certain lines. For example, who's opening first, who's closing first? I mean, it seems to me that was proceeding along a certain presumption that your client had the burden of proof. So isn't it a little bit late to raise that issue after the judge renders a verdict?
If I may modify my statement, Your Honor, I'm not sure that it wasn't raised, but I can't point Your Honor to a place in the record where it was. And when I read that, the way that the judge framed that at the end of trial, when trial counsel did raise it after the judge read his findings from the bench, I would note that the judge doesn't, for example, seem surprised by it. It doesn't appear to be the first time the judge is hearing it. And I'm reading that from that point that Your Honor identified. I'm not referring to elsewhere in the papers, but it does seem like something that the judge at least had heard before from the way I read the transcript. And I would say that it was preserved in the sense that it was raised. And it is troubling, particularly here, where we have a very restrictive the conservation restriction, which has limited, narrow exceptions. And this goes back to the point we were discussing previously. Wildlands Trust was in some ways unable, because of what happened in discovery, to prove that which should have been Cedar Hill's burden to prove. And I would say that that remains an error which infected the trial as a whole.
So this is my final question. I'm sorry, this is my final question, then I'll let Judge Englander and Judge Hand ask their final questions of you. The case law you cite to support the proposition that the burden of proof should have been on Cedar Hill tend to be from the insurance industry, or I think there's a landlord-tenant case. Are there any such cases involving conservation restrictions, or in some area of law that's a little bit more akin to this type of contract or restriction, as opposed to insurance law, which you're dealing with, by definition, you're dealing with exceptions and exceptions to the exceptions when you're dealing with comprehensive insurance policies?
Your Honor is certainly right that the Murray case from the 1940s is an insurance case. The next one Your Honor references is the Corbett v. Derman Shoe. That's the landlord-tenant one. So it does take it out of the insurance context and applies that principle elsewhere. I am aware of a more recent case from 1997, which is Highland versus Aerovox. That's 424 Mass 226. That's not a conservation restriction case. In that case, the issue was whether there was a duty to indemnify in hazardous waste cleanup. But I think what that shows is that this principle has been expanded, certainly outside the insurance context. And I would say that the conservation restriction context is one in which it's peculiarly applicable. We have this oddity where that which is not permitted is prohibited. So in this way, I think it's consistent with the other cases that the burden goes with the party that would have the appropriate amount of information on that issue. And so here, for example, in the Corbett case, the question was the landlord's going to pay up to $500 in damages, and then the burden shifts to the lessee to show whether there's the damage is due to reasonable wear and tear, reasonable use. Here we'd say the burden shifts to Cedar Hill to show that they come within one of the very limited 17 exceptions to the general rule that activities on the land are prohibited. So I think conceptually it holds together quite well and quite appropriately.
All right, so then that gets me right back to the first question that Judge Neyman asked, which is, how do we enforce this against the judge if it's not raised until closing arguments or even after them? Am I understanding correctly that the first time that your side raised this concern was after the judge had talked about where the burden of proof was throughout his entire opinion?
As far as I know, that may be correct, although again, the judge doesn't express surprise.
Asking us to find error by the court on an issue not raised until the court had rendered his final decision.
Yes, Your Honor, I am. Because it's an error of such dimension, I think it's important. I would.
Continue, Attorney Musgrave, sorry.
I would also note that this error is one that is capable of repetition because the parties remain in this relationship. And so it matters for their relationship going forward whose burden it is to show whether Cedar Hill's activities, the activities about which they have the most information, come within this conservation restriction, this admittedly especially strict one. And so even were the court not inclined to reverse, although for the reasons we've cited in our briefs, I think that's appropriate, at a minimum, there should be some statement about what the law is on this point.
Justice Hand, any further questions?
No, I think you've covered it. Thank you.
Justice Englander?
I'm fine, thanks.
Well, thank you very much. And we will also, we would like to acknowledge also the amicus brief submitted on behalf of the appellant from the Audubon Society as well. So very helpful. Thank you.
Thank you, Your
We'll hear
Honors.
now from counsel for the appellee, Attorney Morgan.
Thank you, Your Honor. May it please the court, Jason Morgan on behalf of Cedar Hill Retreat Center. Thank you for your time as well, and thank you to your staff. They've done a nice job at putting this together and allowing it to go forward. I think one of the things that we didn't talk about yet today that are actually some really important findings are the factual findings by Judge Salinger, which seem to be all but ignored as part of the ultimate decisions here, at least by the appellant. And there are some important things related to the factual findings by the judge, specifically to those related to what notices are really at play, whether or not there was a proper notice that would have triggered the dispute resolution provisions of the conservation restriction, specifically as to when there would be a trigger for opposing a family retreat, and then again a year later as to when there would be a trigger for opposing a management staff retreat.
So, I mean, he addresses at least 5 or 6 instances of use by corporations for retreat purposes, right? And I was assuming those were all post-notice or subject to notice.
No, that's I don't believe that that's an accurate statement. I believe that the witnesses that were put on, and just to be clear, again, as part of the factual findings, there were no witnesses put on by the appellant with regard to family retreats, and the judge noted that in his decision. There were only a handful of witnesses put on with the corporate retreats, the management staff retreats, and I believe only one of those were post 2016. And even with regard to that witness and the ones that were before 2016, the judge specifically found that the witnesses that were called had no personal knowledge of the actual retreats or what activities would have transpired during those retreats themselves. So we're dealing here with a factual record that, despite the legal issues, and I'm happy to address legal issues as well, a factual record that wouldn't allow a finding of a breach of the conservation restriction because there was simply no evidence to suggest there was a breach almost under any interpretation of the conservation restriction.
There's a reference in the briefs to 1,100 days, which I took to be 1,100 days of paid use. Is that in the record?
I don't know the days. I'm not familiar with that reference. There certainly were a number of days per year. There was some evidence, I believe, in the record as to the families or the entities that would have used the retreat at any given time. I don't know specifically, as I sit here, what is in the record in terms of days, amounts of money, anything like that.
Well, so let me ask the question this way. How often under this particular restriction, B3, how often do you think you could use this thing for classes, conference, and retreats and still be consistent with the purposes set forth in section 2? Do you think you could use it 1 out of every 3 days?
The conservation restriction is silent as to the number of days, so I couldn't say, I wouldn't be the person to say what number of days would be appropriate or not, although under the conservation restriction itself, in theory, you could do it as often as you were able to, provided that you were complying with the purpose section, which would essentially say don't materially impact.
So your position, your client's position is that you could run a paid hospitality place just as the plaintiff suggests.
Not at all.
Literally have people there every day under paying for use of the premises. As long as they do what? They take a walk and enjoy the birds?
Well, no. First of all, there clearly was not in the record that the retreat center was used every day of the year. In fact, I believe the record is that in no particular year was it used, more than half, or maybe even less than that throughout the course of the year.
Well, I mean, we're in Duxbury, right? So you're not going to get a lot of use in the winter.
Correct.
So,
and my understanding is there were very limited use.
Are paying, and that's consistent with the purposes of section 2?
Well, to be clear, the term hospitality enterprise was used by Wildlands Trust to describe what was going on. The judge rejected that as a factual matter, and there was,
Right,
again,
and it's just a characterization. So we can leave the characterization aside and ask factual questions. That's what I'm trying to do. What's the record show us? Question number one, what does the record show us with respect to how often this was used as a paid retreat? And number two, what's the position of the defendant with respect to how many days a year they could use it consistently with the purposes of Section 2? I think you've answered two. You've said as much as we want.
Well, all I'm saying is the conservation restriction does not put a limit on it. So as a realistic matter, as you indicated during the winter, I don't believe it's used at all. And I can tell you that it is used for purposes other than Section 3B3. For example, the nonprofit Cedar Hill Retreat Center itself will use it for its own purposes for retreats or meetings and things like that, which they're allowed to do. So there are certainly a host of uses of the retreat center that have nothing to do with any paid retreats, classes, or conferences. I can't give you a reference as I sit here as to the number of days it has been used. I think as a practical matter, it hasn't been overused, which was the allegation. And I would specifically say, in addition to the lack of witnesses that were put on to suggest an overuse, there is zero allegations in the complaint or the amended complaint, zero evidence at trial, and zero suggestion in any of the appellate briefs that there has been any harm or damage to the property. There's not a single bit of evidence that any of the uses that would have been allowed under Section 3B3 have impaired at all the environmental aspects of the property. Not even an overtreading of grass, not even a breaking of sticks. There is no evidence at all. And if you were to go there, and the judge he did a view prior to the first day of trial, and you see, and as noted by counsel, it's a pristine piece of property, and it remains that way. And there is, again, zero evidence that that's been impacted over the course of time that Cedar Hill has run the retreat center. And I think that's important.
Sorry to interrupt. I want to move away. Our time's limited, a little bit away from the facts and get back into the law. The judge, as I understand it, interpreted the conservation restriction in a way that added the term quiet enjoyment from Section 3B1, almost added it from 3B1 into 3B3, if you will. And that's certainly something that the plaintiffs take issue with. And I noticed in your brief, you don't really address that. It almost seems that, I don't know if you disagree with the judge's articulation of the standard or not. You seem to, you don't really address the issue of the implementation of quiet enjoyment into the standard. Can you address that, please?
Sure, Your Honor. As a preliminary matter, the quiet enjoyment aspect was never something that the witnesses at trial spoke to. And so it really was a focus on the use and material part or promote the aesthetic or ecological condition of the property, which is the second part of that, which has been completely ignored by Wildlands Trust in its brief. So there wasn't a focus at trial on this quiet enjoyment standard. I don't disagree that the quiet enjoyment terminology, that specific term, occurs in a different section. I think, as noted earlier, I forget by which justice, the suggestion what the judge was doing here was trying to make a legal interpretation of the section to provide essentially in a declaratory judgment fashion how to interpret this. We all, when we briefed this issue, had our interpretations as to how we thought the conservation restriction should be read reasonably in accordance with the purposes. The judge outlined his specifics of that. We had a slightly different view. We thought the judge's view was slightly more restrictive than we would have liked, but under his interpretation, we thought it was a reasonable interpretation.
That's my question, right? Our review, at least as to the legal issues, is de novo. So my question is, was the trial judge's articulation of the meaning of the conservation restriction correct?
I believe it was. Again, you could split hairs on how to, if we all drafted the interpretation ourselves, we probably would be using different terms to describe that if we were drafting the brief ourselves. But in whole, I think it was a reasonable interpretation in light of the purposes section and in light of the intent and purposes of the conservation restriction itself.
And my next question involves something that I also don't think is addressed in your brief. I don't think you addressed section 4E, which is the non-waiver of rights provision in the conservation restriction. So what is meant by that provision?
Well, the non-waiver of rights provision, I think it's a red herring, and it wasn't something that was brought up at trial. What it is, it's an attempt to basically say, okay, we have a non-waiver provision, so we don't waive our rights. But that's not what the judge found. He used in different parts of his opinion. Sometimes he used you're barred because you didn't comply, or he would say you waived it because you didn't comply. Essentially, what he was finding is that you failed to comply with the dispute resolution provision of the conservation restriction, which was a condition precedent to you proceeding. And that, in fact, bars you from proceeding. So when you say waiver, he's specific, and again, he made factual findings as to the specific notices. Is this a proper notice?
But it's a term in a contract. It's a term in a contract, so it has to have legal meaning. So my question is, what is meant by that non-waiver clause? It's very brief. It's one sentence, I think.
And I would agree. I mean, generally speaking, non-waiver provisions they are what they are, right? But this isn't what the judge was relying upon. He didn't say you waived your rights because of this. He said you didn't comply with these particular sections of the conservation restriction.
Right, but doesn't a non-waiver provision? I mean, it seems to be somewhat. It's boilerplate language. I think in the amicus they said this comes from the model agreement or the sample agreement. I mean, a non-waiver of rights clause can mean different things, but as I read this one, doesn't it mean that no matter how we challenge the defendant's alleged violations, we're not waiving our ability to bring challenges in other ways?
Well, so long as you comply with the remainder of the conservation restriction, I would agree with that. But the legal remedies section.
That last language I don't see in the provision.
I'm sorry?
I don't see the language in the provision that says so long as you comply with the other provisions. I know that we have to read the contract as a harmonious whole, and we'll do that.
That's what I'm suggesting. I mean, if you look at the section 4, it says, and specifically what we're talking about here is an entity, Wildlands Trust, funded by the neighbor, the Reeds, who is trying to put their neighbor out of commission so that they can have zero activity next door. So what you have here is you have them trying to get an enforcement action that they claim they'd be entitled to attorney's fees. And what the language of the contract says under section D is that the parties agree that any enforcement action will not be undertaken until the parties have completed dispute resolution procedures set forth in section 4F below. And then when you look at section 4F below and section 4A, they have written notice requirements. And they also have a requirement that the parties make every reasonable effort to resolve problems before pursuing an enforcement action. And all the judge said is, there was never even an argument on the non-waiver issue. All the judge said is he said, listen, if you're going to pursue an enforcement action and try to get your attorney's fees here, you have to do what this contract says you have to do in order to bring the enforcement action. It doesn't mean that you can't go and get a declaratory judgment action. It doesn't mean that you can't go and say, I want a finding and I'm going to sue to get a declaration that this particular activity wouldn't comply. But what he's saying is you can't have an enforcement action and recover your attorney's fees unless you specifically comply with the requirements of section 4A, 4B, and 4F. And that's really what this case is about. They want their attorney's fees because they want to try and put Cedar Hill under, and they can't do that because they didn't comply with the dispute resolution provisions.
I would have thought that if you're using it 1 out of every 3 days, that there might be some reason to think it wasn't being used consistently with the purposes of the grant. I'm just, just as a possible alternative to trying to put Cedar Hill under, that might have been part of their motivation. Can I ask you this question? With respect to the clause 4A, what are we supposed to do with, upon receipt of this written notice, grantor shall either immediately cease or immediately cease? Doesn't that mean you had to immediately cease?
Well, there's maybe 2 or 3 answers to that. With the concern of not only Judge Salinger at trial, but Judge Sanders, who ruled on previous discovery motions, was you can't come in and say something is a violation when it clearly is not, and make Cedar Hill stop doing it. So if we can be reasonable in our interpretation about what you're doing to overreach here, then we can't just have you stifle them not ad nauseum by saying something's a violation when in fact it's not. And that was a concern by both judges that had been on the case
That's
here.
a very understandable concern, but let's play it out. So they come and they say hey, you're violating this. You're not using it for religious or charitable purposes. You say, that's no way to read this thing. That's just wrong. But you now are stuck with this contract that you signed that says you have to immediately cease. Are there other things you could do at that point? Could you come in and get an injunction saying, hey, I'm being irreparably harmed in my use of the property because they're unreasonably enforcing, or they're taking an unreasonable position with respect to this contract, and join them from telling us about this? Could you have done that?
I mean, in theory, yes, but not without following all of the dispute resolution procedures, which would take several months to get to that point. The separate part of that is what the trial judge found, and I think is appropriate. Again, I think a red herring here is if Cedar Hill had brought suit and there was a finding that it hadn't complied with it before it brought an enforcement suit or brought some kind of an action, I would understand, this as a potential issue. But the fact of the matter is, the judge said, listen, we're talking about what Wildlands Trust is doing and what Wildlands Trust is attempting to do, which is to recover its fees in an enforcement action. Independent of what Cedar Hill does, Wildlands Trust has specific requirements that it has to meet in order to bring that enforcement action, and it didn't follow those. So in that context, it becomes a red herring in terms of what—
I don't think it's a red herring if it says that in the contract, counsel. I don't understand the words red herring. That's what the agreement says. We have to figure out what it means. You want us to construe it the way the judge did, which is essentially to shunt it aside if, in someone's view, not clear to me whose, they think that the position is unreasonable. Is that a way to construe that language?
Well, I think that paints it with a color that I don't think existed at any time, and it doesn't appear in the evidence. But I would suggest that when there was something that was specific, the evidence was. So if we go back to the notices that the judge found had actually been resolved to the satisfaction of Wildlands Trust, a parking issue. So immediately, Cedar Hill did in fact go out when there was a complaint and resolve the parking issue. So something like that you can resolve in real time would be something that would fall under that. When you simply give this blanket statement that says, I object to you using the retreat center for overnight guests, and there's nothing in the conservation restriction that speaks to overnight guests or the ability to have overnight guests, that would be an unfair and unreasonable way to say you need to cease immediately. And I think that's what the judge's concern was. And that also applied with regard to family retreats. And just to be clear, up through the trial, the complaint was family retreats generally.
Fair, then the clause doesn't apply. I'm really struggling with this. I mean, it's an agreement. There are parts of this agreement that you folks want to have enforced very strictly. And then when we get to this language, you don't have an argument as to why we should avoid. You have an argument as to why we should avoid construing it strictly, but you don't have an argument as to why it doesn't mean what it says. It says immediately cease, right?
It says immediately cease. I don't dispute that. I think we have to be reasonable in how we interpret it, especially under the circumstances. And so in particular here, there are only two triggers here. A February 2016 letter that triggers family retreats. The conservation restriction specifically allows retreats, and the judge had previously found, not subject to appeal, that retreats included a variety of things, not just religious retreats, as was argued by Wildlands Trust. So when you come in and say you can't have family retreats, and we already have a decision saying that you're allowed to have retreats that could be religious, non-religious, then I believe it would be unreasonable for them to simply say you can't have family retreats, even though we know and we can say now that that's an allowed use. So if they said, for example, they sent a notice of violation saying you're not allowed to have any human beings in the retreat center, that would be unreasonable to say, okay, we can't even go into the retreat center now simply because they objected. And now we have to go through months of dispute resolution procedure.
Right, but I mean, that's the problem, isn't it? The problem is with the agreement and its language. I mean, what occurs to me, what you're really saying is, or I shouldn't put it this way, but one thing you could be saying is they've taken an unreasonable position. They're costing us money. That's unfair. There is another way to do this other than to ignore the language of the agreement. You go into court, you take the position, you get a judge to say, you're absolutely right, they were totally unreasonable and they need to pay you for the costs that you've incurred as a result of their totally unreasonable position.
We don't have
that would be another way this could play out. What's wrong with that?
Because there's
before you answer, Attorney Moore, before you answer, we are substantially over your time, but we said we would give you more time. So please answer Justice Englander's question. Then I'm going to ask you a question about burden of proof and see if my colleagues have any further questions at that point. Go ahead.
Thank you. I think the problem with that is the conservation restriction is unilateral in its award of attorney's fees. It wouldn't give Cedar Hill the right to recover attorney's fees if it went in to do that. And I think more to your point is the factual premise of if Cedar Hill was the one going in to seek relief, then I would understand, and I think this is what Judge Salinger said, then we could start to talk about what the conditions precedent were for Cedar Hill to go in. But what he was focusing on were the conditions precedent to Wildlands Trust going in on an enforcement action, and that's independent of what Cedar Hill was doing. It had requirements it had to follow, and it didn't do that.
As to burden of proof, just briefly, give me your very best case or very best authority for the proposition that the judge applied the correct burden of proof at trial.
In terms of a legal authority or just my position, the argument on it, I think
legal authority would be perfect.
I don't have my brief in front to give you the case, but the general.
Let's rely on the case, if not just, but if you're relying on the cases in your brief, that's fine. I just want to make.
I'm relying on the cases in our brief, and I think we hit this a little bit, or Your Honor may have hit it a little bit squarely when we talked about this case, both at summary judgment and at pretrial, and then throughout trial. It was always Wildlands Trust who was making the affirmative statements as to what it was attempting to prove. At no time during summary judgment, during discovery disputes, at no time during pretrial, at no time during the trial, did we have any issue or even suggestion that they wouldn't be having the burden.
I understand. I'm proceeding under the assumption that the issue was properly preserved.
Okay. Well, I mean, I would suggest that it wasn't properly preserved, but I think that the plaintiff, and again, maybe we have the cases in our brief that I can't point to immediately, but the plaintiff made the allegations, and I think it's an unfair statement to say that they made a general allegation and that we relied upon an exception. That's simply not true. And if you look at the complaint and the amended complaint, they made a specific allegation of a violation of Section 3B3 as to the nature of the retreats that were specifically in that section. At no time did we say, oh, you know what, you're alleging that we violated the conservation restriction, but we're going to point you to Section 3B3, right? They actually said affirmatively, you're breaching Section 3B3.
Your argument, I understand your argument. Justice Hand?
All set, thank you.
Justice Englander?
All set.
No, thank you both for your arguments and your outstanding briefs. Both parties have been excellent.
All right, we are live.
Calling our final case of the day, 2019 P323, MD versus BD. I would remind counsel that we are being live streamed, so this is not only being held live, but also you're being recorded. I would also remind counsel that this case is partially impounded, so please refrain from using the names of either of the parties. We will hear first from counsel for the appellant, Attorney Baer.
Good afternoon, Your Honors. If it pleases the court, the current case before you concerns the issuance of a harassment protective order issued pursuant to Mass General Law 250E against the appellant BD. BD asks that the court vacate this order. Under Chapter 258E, Section 3, a protective order shall issue based upon a finding of harassment. Harassment is defined under the statute as 3 or more acts of willful and malicious conduct aimed at a specific person with the intent to cause fear, intimidation, abuse, or damage to property. And these 3 acts must actually have caused fear, intimidation, abuse, or damage to property. The burden is on the individual seeking the order to prove by a preponderance of the evidence that 3 such acts are malicious and willful. It's our contention that the appellee, MD, failed to provide evidence of the 3 requisite acts during the hearing before the lower court.
Attorney Baer, you said in your brief that there was no evidence of 3 distinct acts, and you then go on to say the evidence was either uncorroborated or simply doesn't meet the threshold standard. Just briefly, must testimony be corroborated to prove an act?
Well, Your Honor, I think part of the problem is that we don't know which acts the judge cited in his order.
All right, but go back. This is a preliminary question before we get to the acts themselves. You say many are uncorroborated. Need they be corroborated is my question.
Not necessarily. If the lower court judge finds the individual, obviously, who testified as being credible, I think that would be enough, Your Honor.
Okay.
But my argument is we don't know which individual or which testimony the judge found credible or not.
Let me just ask you a question about one of the incidents, the one on June 4th, 2017. If the judge found MD's, or let's say the plaintiff's story credible, that is that the defendant grabbed her arm, called her a name, which I won't repeat here.
Yes.
Followed her, kept yelling at her, tried to grab her again, I believe. If the judge credited all of that evidence, would that be sufficient to demonstrate one of the 3 distinct acts?
Yes, I would agree with that.
Okay. What about the incident at the restaurant?
Again, if the judge credited.
If it was credited, that would be sufficient?
Yes. I think the problem ultimately is that the other 8 incidents, there's no evidence of any willful or malicious conduct directed at MD.
Does the conduct have to be directed at one person only, or could the conduct be directed jointly at, for example, the husband and wife?
The statute says directed towards the specific person.
Right, but if it's directed to both, for example, could it not be directed simultaneously to 2 separate people with the same intent and with arguably the same result?
I didn't see any case law on that. All the case law that I read shows that it's directed towards the specific person.
What about the Facebook post? What do we do with that?
Your Honor, the Facebook post does not mention MD whatsoever.
But it has a picture of their house, or one could find it was a picture of their house?
I don't believe that it showed that there was a picture of the house. I think it was.
Did MD so testify?
I don't believe that there was in the record. I believe it was someone else's house. But there's no reference to MD in the post. There's nothing directed towards her.
Oh,
there's no threat.
And then there's a reference to thieves.
I understand, Your Honor, but there's no threat of any sort of physical violence. I think this would be the type of incident that would be protected under the First Amendment that the O'Brien case talked about. I don't see any evidence of it being directed towards MD or any true threats or fighting words involved in that post whatsoever.
So that's an argument that even if we found that it was directed at MD, and even if we found it was done with the intent to intimidate, or more accurately, even if we determined that the record was sufficient for the judge to so find, under the First Amendment, it could not be a basis.
I don't believe so. Yes, I don't believe so under the O'Brien case, Your Honor. You kind of, just going back, I was going to go through chronologically through the 10 incidents. The first 2 incidents, I think, yes, there is evidence of possible malicious and willful conduct. However, I would argue that there's no credible evidence, that it hasn't been corroborated, and that in fact there was evidence, especially with the first, the graduation party incident, where there was a neighbor who observed the entire incident from a second floor window, and he testified that he never saw BD touch or speak with MD. I would argue that that kind of contradicted MD's, or that did contradict MD's version of events.
Right,
And
but
again,
counsel, that's an argument that goes to the weight and credibility for the trial judge to determine, right?
absolutely, Your Honor. I think it goes back to the ultimate problem is we don't know which 3 acts that the trial judge determined constituted.
The case law, as I understand it, he or she, I can't remember what we have, who the judge was, but they don't have to tell us which 3 acts, do they? They have to make findings.
Well, I think the statute doesn't say that, Your Honor, but I think it's problematic at anyone challenging, especially where there's anyone challenging the issuance of the harassment order, prevention order. I think it's problematic because if there's multiple, as in this case, where there's 10 incidents, it's hard to determine which ones and which weight that the trial judge found, credibility, where he credited testimony and such.
Was there any request along the way for the judge to make those findings?
I do not believe so, Your Honor. I don't see anything in the statute that requires.
Putting that aside, was there any requests?
No, not to
required or not?
Yeah, not to my knowledge, Your Honor. But just going back, again, an analysis of the incidents, then there's the next incident again, which there is possible evidence of malicious and willful conduct, is the June 18th restaurant incident where MD had gone out with her husband to the restaurant. They were leaving, and then they ran into BD and her husband. At that point, again, BD.
We're familiar with the facts. I promise you.
Okay, but just going on, the next incident, the third alleged incident, is a 911 phone call in which MD doesn't allege that BD even phoned in the 911 phone call. It was BD's sister. It wasn't
her that was BD who did it.
Sorry. My understanding of the record is BD's sister testified that she in fact called 911. And I don't think there's any allegation that BD called 911. I'm also, I don't know that calling 911 and reporting a party would rise to the level of malicious conduct.
Well, you have a First Amendment issue, right? Sorry, go ahead, Judge.
No, my question was going to be, what about the evidence of the fact that your client called the police supervisors to let them know, to give them a heads up that the 911 was coming in? Could the judge have inferred from that an intent to, a malicious intent to harass the husband and wife who owned that home?
I guess my argument, Your Honor, would be that it's kind of putting the cart ahead of the horse, insofar as you have to have the act and then you look at the intent, the way the statute's written. So you have to show that there was conduct, and was it intended to cause fear or harm, and was it directed at the specific person? My argument would be that it wasn't directed towards MD, and it wasn't even committed by BD involving MD. It was BD's sister.
Right, but didn't BD, learning that her sister was going to make that call, make what might be termed a courtesy call to the department to let the department know that that call was coming in?
Yes, she did. She alerted her supervisor, and I believe there was testimony because she was concerned that there had been those prior incidents. So she was just letting him know, giving him a heads up that this phone call had occurred.
And could the judge infer that based on that call, rather than the 911 call itself, 2 captains and the head of the Federation, if I'm remembering correctly, went to the house in response?
I think he could certainly infer that. I don't see how that, even if we take that as one of the acts, which she didn't allege, MD never alleged was one of the acts, how that again goes back to how is it willful and malicious conduct? How is it a threat aimed directly at
I'm sorry to
MD?
interrupt, but is it willful and malicious if there was no party and your client, again, let's assume that inferences could be drawn, that your client knew there was no party and knew that MD was, going out to dinner with her husband and that there would just be children at the house, and made the call for a malicious purpose, i.e. there is no party going on, but we're going to send police over there anyway to scare the family. Assume that could be inferred. Would that satisfy the test?
No, I would say no. I would say under O'Brien, it's a heightened, especially something like that. I think it's heightened because if you delve down, if you dig down into malicious, it's characterized by cruelty, hostility, or revenge. And then O'Brien narrowed it even further to call it, to say either it had to be constituted as a true threat, an attempt to cause physical harm or actually cause physical harm, or fighting words. I don't think either one apply in that case. So I wouldn't say, Your Honor, that malicious, that it would be considered malicious and willful conduct.
Can I ask a procedural question, which is, my understanding was that the 258E order at issue in this appeal was due to expire in July of 2019. Is that correct?
Yes, Your Honor. There was a hearing. Now, I wasn't privy to that, but there was a hearing before the same judge, and he declined to extend the order.
So there's no order presently in place.
Correct.
So that begs the question whether or not this issue is moot.
And there's a case, it's the, one second, Your Honor. It talks about, there's a Mass Appeals Court case that talks about AR versus LC, and it talks about because of the very nature, once one of these orders issues under 258E, your name goes on the domestic violence registry, and it's considered a criminal offense. So there could be all sorts of negative ramifications for the individual who it's been issued against, especially since she's a member of the Boston Police Department. And my understanding is under this domestic violence registry, it won't be expunged.
Yeah, I don't think it's that it's criminal. I think it's that it could have consequences or ramifications.
Yes, absolutely, Your Honor. I would agree with that.
Counsel, when the order entered in the first place, they take away your gun like they do in a 209A?
No, Your Honor. I don't believe so. There were other things going on at the time. I know that her gun, her weapon was confiscated at one point, but I don't believe that I don't know whether it was before or after this, but it wasn't linked to this order. I don't believe. Again, just looking at the remaining incidents cited by MD, there's the egging incidents that occurred in September and November. There's no evidence that BD was involved in this, and in fact, MD testified at hearing that she had no idea who did it. My understanding is BD put or installed a surveillance camera outside of her house, and she did pick up in the November egging incident an individual, a young male. And again, there was no evidence showing that this person was or that BD was involved in that. All I would say to just wrap this up is that if you look at all the incidents, the last remaining 8 incidents, there's simply nothing, there's no malicious or willful conduct being directed at MD. It's all either suspicious, she had suspicions, or it wasn't directed at her. Thank you.
Attorney Bear. We appreciate your presentation, and we will now hear from counsel for the appellee, Attorney Traft.
Thank you, Your Honors. Thank you for your patience today. I have been watching earlier and it's been very difficult. So let me just get right into it. The important thing here is to consider the context of this whole case and the parties involved. The plaintiff is a teacher. Her husband's a police officer. The other parties are both police officers. And that's the underlying issue throughout all of these various incidents. If you had just neighbors who had no connection to the police department, this might be a different story. But here,
sorry to interrupt you, but didn't the evidence suggest that the real issue here arose out of the June 4th incident, and it was between your client and MD's husband, that there's a very clear difference of opinion as to exactly what happened on that night, but the issue was with MD's husband.
Yes, but that was it can be inferred, and which is what the plaintiff argued, was a reaction. His action was a reaction to what the defendant had done in confronting the plaintiff in this case. Because there was one incident, they're talking about trying to cut the party down. So then she comes back out a second time. And that's when she confronts the plaintiff and yells foul words at her and so forth. And as I think the plaintiff has acknowledged, that it can qualify as one of as the initial incident. So it really was directed at her. And that's the basis for the first incident.
Let's for sake of argument, let's concede you number one. Let's concede you the restaurant, although I think we might come back to that. What is of the remaining 8 instances that were identified and briefed? Which one do you hold as the third? Which incident?
Well, probably the last 2, and because they were the ones that initiated this complaint, being filed 11 months after the first
one
incident.
of those is the Amazon delivery incident, and the other one is the communion party, right?
Correct. That's right.
Okay. So the Amazon delivery, what is it that BD did that you say was with the intent to cause a fear or intimidation?
By making a report to the police department that this was a stolen property, when she had all of the information, or could have done exactly what the plaintiff did, and that is contact.
Making a report to the police department seems to me to be pretty much a core First Amendment protected behavior. Why wouldn't, I mean, you have the right to petition the government for redress of grievances, and asking the police department to do something seems to me to be pretty much in that wheelhouse. Why would this fall outside of a First Amendment protected activity under O'Brien?
Because she was aware exactly of what the circumstances, that this wasn't a stolen property of any sort. And she could have called Amazon as the plaintiff had done. Now, you have to remember the timing here. Friday.
So maybe a false petition can be outside.
You can, I think the problem, what makes it outside is by making a false complaint that she knows is false, and rather than trying to find out specifically from Amazon whether this delivery was incorrect and whether they would correct.
Counsel, it seems to me that there are other ways to punish someone for making a false claim to the government, but saying that it's not protected strikes me as a difficult road for you. Do you have any case that suggests that you can meet one of the 3 tests of harassment when what you've done is a direct petition to the government?
When you're making a direct petition to the government, that's completely inaccurate in the context.
Do you have any case that suggests that that could be sufficient?
It's in case direct threat in that respect, and that's what I'm saying. I don't know if there's any other more specific case than some of the other cases that have been involved and cited in the brief. Right.
Okay.
All right. Now, the other incident was is related to this, and that is the incident involving their son. The judge could infer, as the plaintiff argued, that the son was invited over to that house. And we hadn't been to that house since this June incident 11 months before. She could, or the judge rather, could infer that the son was invited over there, and it was done as a way, as a taunt, to show that their family and their child is not free from a potential harm. And you have to look at it in the context too. The criminal complaint is going on at this point. This had been transformed from a departmental complaint where the department decided not to move anything. They moved forward with a criminal complaint starting in January. It had already gone through some series of hearings. And so for the defendant to have invited the son over during this party, and then keep him there for a period of minutes inside the house, record him on their own video recording machine without knowledge or consent of the parents, and then allowing him back. That's a clear taunt that they could inflict physical damage on members of.
I'm sorry to interrupt. I saw
Yes.
the evidence that the defendant was not invited to the communion party. She gave the son $20 gift and a card and I think a freeze pop. Where is the evidence as to, number one, how long the son was at her house, and also where is the evidence that he was invited over?
Well, in terms of the evidence of how long, I believe the plaintiff testified she believed it was approximately 15 minutes. The defendant testified based on the recording. They had a recording of at least 7 or 8 minutes. How long that whole transpired, or somewhere in between that, but it was still a period of time that he was inside the house without the knowledge and without the consent of the plaintiff.
Didn't your client testify that she knew that the child was there because she'd seen him go over the wall, and then she sent another child over eventually to go collect him? Isn't that correct?
Well, she saw him go over the wall and thought he was only going to retrieve a ball and be right back. And when she didn't come back, she didn't know where he was. She asked some of the other children, who then finally told her they thought he went into the house. So that's what went over. Yeah.
To just ask the question that Judge Neyman asked again, where is the evidence in the record that he was enticed or requested or asked to come over?
It can be inferred because he had never been over there for the last 11 months, under any circumstances. And there was no particular reason.
From the fact that he hadn't been, you can infer, how do we know he hadn't been over there for the last 11 months? Did MD?
Testimony at the trial. The defendant.
You can infer from the fact that he hadn't been over there that on this day they asked him to come over. That's your argument.
Yes.
And there's nothing else from which you could infer that.
Well, you can infer it from the plaintiff's testimony about the fact there hadn't been any communication, from the defendant's testimony that there was no communication between the two parties before that time.
Let me ask a question differently. If BD did nothing to get the child to come over, would you still argue that there was sufficient evidence of harassment?
I would argue this because of the nature of the animosity between the parties. There was an easier way to say.
What was she supposed to do then? Send the child back?
Sure, just tell him, I'm busy now.
And MD says, boy, that's intimidating. My child went over there and they sent him back.
that wouldn't be intimidating because really there was no communication between the parties. And the idea was if the child had wandered over there on his own, the appropriate action is to have him leave immediately and not have this.
Well, in any other context, an appropriate action on Communion Day might have been to give a very nice note and $20. Would you agree with that? In any other context?
In any other context, right? It's the whole context that's involved here, and that's what makes it a threat. If you had, if it's just another neighbor who they had no relationship with, and the child walks over and this happens, that's a completely different story. But in the context of this case, it's a threat that we have the ability to have control over your children and to potentially inflict harm. And that's the nature of why it meets the statutory criteria. Now, let me touch upon a few other of the issues too. I think it's important to talk about the egging incident. And that's because they also have to be put in context of when these happen. This is not a neighborhood where people are egged every day in the street. The only testimony was no one else had ever had their house egged in that manner ever before. And
Right.
where is it located?
One was after a union report, I think, and one was after a call to the police or something to that effect. Right?
That's right. That's right. They were coincide. One was the first one was the day after the mother had testified in the into the union. So this is why she
that DD engaged in a criminal act solely from the timing of an act and nothing else.
The timing of the act and the particular location in which it's shown. The mother testified that this is aimed at just below the window, the bedroom window where the children sleep. That they changed their bedroom location because of that. So you from the timing of those actions and the fact that it's so out of character for anything else that had happened to anyone else in the neighborhood under any other circumstances. And the fact that they're coincided with these two and given the whole history of the nature of their relationship, that's where you can make the distinction and find that she was responsible for them. And also I would add with the call to the house, it's important that the testimony was that her sister was the one who first called her. And what her sister testifies to is she called her, she saw some young people going into the house and thought there might be some party. Now, what the plaintiff, defendant does is magnify this, goes and talks to her supervisor, says maybe the 911, there'll be a 911 call, obviously encourages her sister to make the 911 call. The sister knows it may not be something she should be doing, so she does it anonymously. And that causes the police department to send out two captains to investigate the situation, and nothing was going on. So
once again, that's even if you assume, well, there were two things buried in that. The first is your statement that she, quote, obviously encouraged her sister to make the call. Was there evidence of that?
I believe that there was with her own testimony. She said she was called by her sister, and she had some discussion about that. And her sister acknowledged also that she had talked to the plaintiff first, defendant first, before she made the call.
Again, this is a petition to the government, right? This is a direct conversation with the government.
Well, it is, but still, it's the question is it done for the purpose of trying to intimidate in the context of this case?
Can I just ask really quickly, why do you say that the statement in the restaurant is sufficient where what BD is reported to have said by your client is, your client says, what do you mean? I'm sorry, your client says, well, if he accepts your apology and he accepts yours, why doesn't it just end there? The response is, that's not how the department works, honey. You better get some fucking thick skin. Why is that? Why is that a threat?
It's a threat because it is, again, she confronts her physically and gives whatever she says in her words, it also gives, it certainly can induce fear that there's potential physical attack in one way or another that could be imposed upon her because of the confrontation that had happened before. And that's what turns it into, if you accept the plaintiff's, as the judge, I think, apparently did, accept the plaintiff's evidence and testimony about what had happened. That's enough to make it one of the three criteria.
Thank you, Attorney Draft. Justice England, or any further questions?
No.
Justice Hand?
No, thank you.
So I'd like to thank both counsel. Thank you for your thorough and helpful briefing, and thank you for your arguments. We appreciate it. I'd also like to thank our clerks and staff for making this sitting possible for us.